Ready?
Sure. All right, good afternoon, everybody. My name is Justin Thompson. I'm the managing attorney with Lone Star Legal Aid's Military and Veterans Unit. Just want to welcome everyone here today. This presentation has been put together by the Houston Area Veteran Legal Services Organizations, specifically the Houston Volunteer Lawyers, South Texas College of Law Houston, Beacon Law, and Lone Star Legal Aid. I'd like to extend a special thanks to the Texas Veterans Commission and the Bob Woodruff Foundation, whose their funding is very invaluable to Lone Star Legal Aid's Military and Veterans Unit. First of all, thank everybody for attending. We thank you for spending the afternoon with us to help more effectively serve those who proudly served our country. All of our organizations deeply appreciate the work that the private bar does on behalf of our veterans. Your work helps multiply our efforts. The presentation today will focus on how you can best represent your clients in matters before the Veterans Administration. This webinar is going to be recorded, and that information will be sent out to you along with the CLE identifying information in the next couple days. A few technical matters about the presentation. Everyone is going to be put on mute so that the presentation can best be heard by everyone. If you have any questions during the presentation, don't hesitate to use the chat or the question functionality here in Zoom on the bottom of your screen. Each presenter has built in some time though to answer questions, and we've also built in some breaks in the presentation for you to stretch your legs, get coffee, answer emails, what have you. So with that, I'd like to hand it off to Diana Carlson with South Texas College of Law Houston.
Thank you, Justin. Just to echo what he was saying, we really appreciate you all joining us today and getting your VA accreditation or continuing your VA accreditation. Andrew Lehman and I are going to begin the presentation, and we're going to share it on our screen so everyone can view it. If you cannot see the PowerPoint, please let us know in the chat, or please let us know in the chat or the question and answer box. All right. Robert, I just enabled sharing, so you should be able to. Okay, great. Robert, next screen, please. We're going to start off just with some basic information here for those who are new to this area or unfamiliar with Department of Veterans Affairs. As you can see on this slide, the Department of Veterans Affairs is basically the umbrella, and within it are 3 different organizations. You have the Veterans Benefits Administration, the Veterans Health Administration, and the National Cemetery Administration. We're going to be focusing today on the VBA. I did want to mention that the Veterans Health Administration is another pretty well-known organization. They administer veterans healthcare, things like substance abuse counseling, mental health, housing assistance, but they are a separate organization from the VBA. So they don't really share the same systems, and they don't really communicate, which can be frustrating for veterans. So just keep that in mind when you are representing veterans. Next slide, please, Robert. All right, just a little illustrations here for you. Andrew, if you want to start your portion.
Hello, my name is Andrew Lehman. I have not done this before on Zoom, as some of us hasn't before, so it's going to be a little bit different for me. I was going to put a laugh track up there for these to kind of get the message across, but there's going to be a few kind of comics and other silly things intersped in here, partially because it's always dry to give this information, and partially because I think some of these are good at kind of communicating things about veterans that you may not know if you are a veteran. So I know that a lot of people listening may be veterans or may have veterans in the family, but part of being able to provide services for veterans is having some level of cultural competency that's going to make it easier to communicate with people that have had very different experiences than you. And so I try to squeeze these in as a little way to communicate some cultural competency. So there's going to be a few of these. Just what you're looking at here is this says holiday leave, but it really represents kind of the three different ways that veterans come out of the military, right? You have people that still live it, you have people that want you to know they lived it, and you have people that don't want you to know anything. And you're going to be dealing with veterans of all three types at some point if you're helping veterans. So it's important to recognize that, you know, there's not one size fits all for how veterans respond or deal with their service after they get out of the military. Next slide, Robert. So I'm going to start by giving a profile of a veteran, and this is different than the legal definition we're going to get into. This is just trying to communicate some information about veterans as a whole, as a population, unrelated to their need for legal services. The reason I do this is because for veterans to get in the news, it's usually something bad. We don't get in the news when we do something good. We don't get in the news when everything's working right. We don't get in the news when the VA is doing its job. And just to understand that those are really important things to know and to hear about, but there's also a kind of larger veteran population that's not always going to be part of that conversation. So Texas has a huge population of veterans, higher per capita than a lot of other states. Part of it is because there's large military bases here, and because it's got a younger population. Retirees like coming here. Lots of people stationed here stay here. But the veteran population overall is shrinking. The reason is because the government used to draft millions of people a year in the 50s, 60s, and 70s. They did, you know, under 2 years of service, and they are veterans, but they no longer need as many people. And now they're recruiting, you know, 150,000, somewhere in that range, and they have been for a few decades. So as the number of veterans that they're recruiting every decade goes down, and as older veterans die, the younger generation that was recruited 20, 30 years later is always going to be smaller. So even though there's a large veteran population, the population as a whole skews older, whiter, and maler than the population as a whole. This makes sense because these are the people that were most likely to be drafted in the 50s through 70s when they were taking in millions of people every year. And the population that's joining the service now and has been for the last 20 years looks a lot more like the population of the young people today, but there's just a lot fewer of them. So understand when you think of a veteran in general, there's definitely a younger veteran population that is the focus of a lot of things we're hearing about right now, but your average veteran is still going to skew older and have had a shorter period of service. A longitudinal study the VA did on the veteran population as a whole, irrespective of whether they needed any other service, was that a person who had served is more likely to own a house, have a job, get married, make more money over their career, and live longer than someone that didn't. They adjusted that, factoring out race, gender, ethnicity, basically trying to look at if you grew up in this house and the house next door and one of you joined the military and one of you did not, your life outcome is more likely to be better than worse. Those are particularly people that generally don't have problems where they come seek a lawyer related to their service, so they're not going to be the ones that you encounter the most. But again, it's trying to dispel the idea that this is the veterans that have problems with the VA are the average veteran. That's not necessarily the case. Most veterans don't receive benefits from the VA other than, I believe, the GI Bill and home housing purchase are the two most common ones. And like I said, service is part of life, but doesn't always define who they are. For some people it is. It's the most important thing they've ever done. It's the most interesting thing they've ever done. And for some people, they are the citizen soldier, the people that served and then left and then moved on and reintegrated. And it's just a part of their life they went through, similar to the period where you go off to college or the period where you first moved out and had a few wild years or a few bad years before you got your act together. It would be no different. It was part of their life, but it doesn't define them. So keep that in mind anytime you're doing an encounter with veterans, that there isn't kind of a template you can fit to say, I know what this person's experience is because I know what a veteran is, because I listen to NPR. That will give you the impression of some, not all. Next slide. I think we're back to Dane.
Okay, so in order to get accredited for the VA, we have to hit on certain topics. One of those is how to represent a veteran before the VA and how to get accredited. Some of you have already done that. Others are just starting out. So we are going to be touching on the basics here for those who are unfamiliar. Hopefully you guys have already filled out your form, but if not, this will kind of get you through that process. So any attorney, organization, agent, or other person can represent a veteran before the VA if you get your accreditation. There is one exception where one person, one time can represent a veteran without having accreditation, but after that, after your one time allowance, you're no longer allowed to do that. So in order to get accredited as an attorney, you're going to file an application with the Office of the General Counsel, and that application is the VA Form 21A. We're going to show you what that looks like. So here we have the application, and you'll see on here the types of information that it's requesting, basic information, obviously your work. Really the important focus here is on the second and third page. We have the top here, number 11A. It's asking you for all the jurisdictions for which you're admitted, your date of admission, and your membership number. And eventually, towards the end, they will have you certify that you are in good standing in all of these jurisdictions. That is required as part of your accreditation. Thank you, Robert. We can go back to the slide when you're ready. Thank you. So once you fill out your application, then you have to do your 3 hours of a CLE, which is partly why you're here, I imagine. After you watch a CLE, you complete your CLE, and when you do your accreditation for the first time, you have to do that CLE within 1 year of the date that you file your application. Upon completion of the CLE, you're just going to submit the CLE title, the date and time that you took it, and identify the CLE provider. You can send that information to the Office of General Counsel. We've provided the email for you. It's on the previous slide, and we'll also provide that email again when we send an email to you all with the CLE information on it. There is no particular form that you need to send with this information. You can email them, and that will suffice. After you're accredited, they will post your information publicly so that veterans can look for attorneys that can help them with their issues in front of the VA. Okay, next slide, please. All right. So we wanted to show you another form, which is really important when you're practicing in front of the VA. Once you're accredited, you also have to submit appropriate paperwork with the VA, informing them that you are the power of attorney, that you are the representative of a veteran. The VA will not talk with you about their claim. They won't talk with you about any correspondence the veteran has received if you do not have this form on file. This form is a VA 2122A, and we'll look at that briefly as well. Okay, so here's the form. You can find this. You'll see at the top the website here, the vba.va.gov. The VA actually is pretty good about supplying all the necessary forms on their website, and this is one of them. You'll go through on this form, you'll identify the veteran's information, and then you'll see down here, if you're a service organization, like the Texas Veterans Commission, for instance, they would fill out this portion. An individual is going to fill out the portion below it. And it's important, one thing that I find often with my clients is they'll sign one of these pages and not both pages. So make sure that you have the veteran sign 17A as well as, I think it's 20, a little lower, 17A, and it's a little lower at the bottom. So there are two locations that the veteran has to sign. You also have to sign both of those locations. So there should be a total of 4 signatures. If 4 signatures are not on this form, the VA won't accept it, and they will not talk with you about the veteran's claim. So just double check that whenever you send these to your clients, because as I said before, I find that a lot of the time they'll miss one of the 2 boxes. Okay, we can go back to the presentation. Okay, so once you're accredited, you submit your form, you do your CLE within the year, and you submit that information to the Office of General Counsel. You have to provide that same office with information every year. That is your identification number and membership information for each bar, court, federal, state agency that you're admitted. And we looked at that form on the 21A. And then you have to certify in writing that you're in good standing in each of those jurisdictions. Again, there's no form for this. You can just simply certify in an email, I am in good standing, and that should suffice. Every 2 years after your initial accreditation, you have to do an additional 3 hours of a qualifying CLE. It's important that it's a qualifying CLE or they are not going to give you credit. This is a qualifying CLE that will give you, that qualifies, for your accreditation in front of the VA. Once you complete your additional CLE, you'll notify the OGC and again, certify in writing the same information, the CLE title, the date and time, and the identification of the CLE provider. And, they prefer that you submit this information all together so they have it all in one place that they can look at. And as I mentioned before, no particular form is required for this. Next slide, please. Once you're accredited, there are certain standards that you have to abide by as an attorney. I think one important one to touch on is that if you're accredited, you can charge a fee for assisting veterans with their claims. If you're not accredited, you cannot. And an important thing to mention here about fees is if you're going to charge veterans a fee for helping them with their claim, you cannot charge them until after the VA has issued its first decision on their claim. You cannot charge them for helping them file their initial claim for benefits. You also have to make sure that you have a fee agreement in place if you're going to charge a fee. And that agreement has certain requirements, which you can find under the Code of Federal Regulations, section 14636. And as I answered in the question and answer box, we will be attaching this PowerPoint to the email that we send y'all after the CLE. So you'll have access to this information and can look back and get it if you need it. There are obviously other professional responsibilities. We're not going to touch on them all, but I have provided a link here for you to review those if you have more questions about that. Next slide, please, Robert. Okay, another thing that's important to touch on is that this accreditation is only going to matter for the VA administration process. Getting accredited with the VA doesn't affect your right to advise and counsel veterans, right? The VA is not going to know if, for instance, HVL has their clinic or did at DeBakey every Friday, and we have volunteer lawyers that attend that. So you don't need to get accredited in order to do that. Additionally, if you're going to be representing veterans in federal court, and we'll get to that a little later about appealing VA decisions in federal court, you don't need accreditation. There is a separate accreditation requirement there, and we'll touch on that, but not in the VA accreditation is not needed. Another thing to touch on is if you are going to if you're going to represent a veteran in a personal hearing, and those all take place in DC now. They used to have traveling boards that would come around each state, certain locations in each state, and you could request a traveling board hearing. You would have to wait a little longer for one of those, but that was a possibility. They are no longer doing that. It's DC only. If you wish to represent a veteran in the DC courts, you should ensure that your client agreement reflects that you will travel with them. They have to pay for travel, or if you don't want to represent them in person, alternatively, that your attorney-client agreement says we're not going to represent you if any hearings involve travel. Note though that they do allow video conferencing, so they've made things a little easier nowadays. Next slide, please. Okay, so when you're representing a veteran, a lot of times they're going to have issues with the VA, right? And one of the main issues that they have is the VA determines they're not eligible for benefits. Now, to qualify for VA benefits, you have to establish two things. You have to show that you are eligible. That means that you meet the VA's definition of what a veteran is. And it's important to note that the definition of a veteran for the VA is not the same as it is across, all organizations. The DoD has a different, sorry, one second. All right, sorry about that. Our wonderful cleaning ladies here at the school. We're stopping by. I've asked them to come back later, so they shouldn't interrupt. Okay, so like I was saying, you have to establish two things: that you're a veteran, you have to meet the VA's definition of what a veteran is, which we're going to touch on next. And you also have to show that you're entitled to a particular benefit. So we're going to start by discussing what the VA's definition of a veteran is. Next slide, Robert. So according to the VA, a veteran means that you're a person who served in the military, in the active military, the Naval or Air Force, and was discharged or released therefrom under conditions other than dishonorable. So if you break that down, there are 4 elements. You served in active duty under one of the federal branches for a minimum amount of time, and you were discharged or released under conditions other than dishonorable. And we're going to touch on each of these elements next. So we're actually going to start with the second element. What are the federal branches of service? Now, I always ask my students this, and they always get the answer wrong because everyone thinks that they know the answer, and they're always surprised when they find out. So in your question and answer box, if you will go through each of these answers, A, B, C, or D, and put what you think the federal branches of services are. I'll give you guys a minute to look these over, and then I'll touch back on them.
I want to jump in for a second. I saw in the chat somebody said Merchant Marines, because they realize the trick that there's some that are not on here, but Merchant Marine is not a federal service. They're not typically considered veterans. So that was not excluded on accident.
Oh, good catch. Okay, so if we're assuming I did not leave off the Air Force on this question, either way, even if the Air Force had been on each of these answers, you'll see that none of you were giving a general consensus here. Some said A, B, C, D, because people, never really know what's all included. And yes, the Air Force should be on here, but the answer is D, right? We have the Army, the Navy, the Marines, Coast Guard, Air Force, Reserves, Space Force, which is a new federal branch, and then the National Guard and the Reserves are included as a federal branch of service in particular situations, which we'll cover on the next slide, actually. Okay, so right? You have to serve in a federal branch of service, and you have to have served in active duty to be considered a veteran. So what is active duty? That means you were either enlisted or commissioned in the regular Army, Navy, Marine Corps, Air Force, or Coast Guard. And if you are in the reserves or in the National Guard, you're only considered active duty when you are federally mobilized on Title 10 or Title 32 orders, depending. So, for instance, the National Guard is usually a state-funded organization, right? The federal government only will pay for National Guard services when the president issues Title 10 orders. Same thing in the reserves. You're only active duty when you are actually mobilized for your service. Okay, next slide, please, Robert. Thank you. All right, Andrew. Andrew put another
reservists are usually not taken as seriously unless they've been called up and given a serious job. So in the last few years, a lot of reservists were called up, but for a long period of time, particularly before they went to all volunteer military, the reserves is where you went to get out of military service. So that's changed a little bit more recently, but it might be shifting back.
All right, so let's move on to element 3. All right, so you have to serve in a federal branch. You have to have served in active duty, and you have to have served for a particular time, but that's going to depend on when you were enlisted or commissioned. If you enlisted or were commissioned before September 7th, 1980, there is no minimum time requirement to qualify as a veteran under VA, under the VA qualifications, right? However, if you enlisted or were commissioned after September 7th, 1980, or you entered active duty after October 16th in 1981, one of these has to be true in order to qualify for benefits. You had to have served at least 24 months consecutively, or if you didn't, you have to meet one of these exceptions. You either served the entire period of time when you were called into active duty, or you suffered a service-connected disability. Now, the exception where you serve the entire period of time is often often applies to a reservist, right? If a reservist gets deployed for 6 months, their unit deploys for 6 months, they serve that entire 6 months and return stateside, they're going to have met that exception, even though they didn't serve 24 months, right? And then service-connected disability, which we'll touch on a little later. Sometimes a soldier will get injured while in service and they're unable to continue in the service, and that's okay. They're still considered a veteran according to the VA, because that's one of the exceptions. Next slide, please. All right, so we have 4 elements. We've gone through the first 3. You have to have been in active duty in a federal branch for a minimum amount of time. And the last element is that you had to have been discharged or released under conditions other than dishonorable. So we're going to talk about what that means. Next slide, please. Thank you. All right. And and I apologize for taking you back to the basics, but when I first started in this area, I did not serve. So there's, some lingo I wasn't familiar with, procedures, policies I wasn't familiar with, and some of you may feel the same way. So when you are discharged from the military, you're given a DD-214, and there's a bunch of information listed on that. And we're gonna review that in a second. Part of the information that's included on your DD-214 is your discharge status, your discharge characterization. Y'all are probably familiar with these. They're things like honorable, dishonorable, other than honorable. And when you're applying to the VA, they have to decide the 4th element, right? They have to decide if a veteran service was under conditions other than dishonorable. So they look at the veteran's records, they look at their discharge status to see the discharge characterization they were given. If a soldier had an honorable or general discharge, then they're going to automatically qualify for VA benefits. That doesn't mean they're going to automatically qualify for the benefit they applied for. You still have to be eligible for that benefit, but that just means they're automatically able to apply and receive a benefit if they end up being eligible for that particular benefit. So, however, not everyone has an honorable or general discharge. So, in those instances, the VA has to go through a process to determine whether that service member served other than dishonorably. And that process is called a character of service determination. And we're going to touch on that a little later as well. But I wanted to mention it now just to kind of understand this fourth element that the VA has to consider with determining eligibility. Next slide, please. Thank you. So if the VA, you meet all three elements, they go to element 4, they decide that you served under conditions that were other than dishonorable, they grant a veteran eligibility for benefits. And a veteran is then eligible for all benefits except the GI Bill. To get the GI Bill, you had to have been discharged honorably. There's no exception to that. Now, as I mentioned before, just because the VA says, hey, you're eligible to receive benefits doesn't mean you're going to get all benefits. You have to qualify for each benefit and you have to apply separately for each benefit. And the VA will then go through and determine if you qualify. One important thing to note is if you're going through a character of service determination, let's say a veteran was discharged with an other than honorable, an OTH, and he applies for a benefit. The VA goes through its process. He meets all requirements. He was active duty. He served for 24 months. He served in the Army. And then it gets to the fourth element, and he served other than honorably, right? That's his discharge characterization. The VA is going to go through its process to make a determination on whether his OTH, his other than honorable discharge characterization, if even though he has that, he has still served other than dishonorably, right? And if the VA finds that veteran served other than dishonorably, like I said earlier, they grant the benefit. And that means that the VA considers that veteran as having served honorably, but it does not change their military record. It does not change their DD-214. Has no effect on the DoD records whatsoever. It's just how the VA views that veteran service with regards to benefits. All right, we're going to review a DD-214, and this is Andrew's DD-214 actually, so I'm going to let him talk to you about it. It kind of touches on some information, some of these elements that we've talked about, and other important information to look for.
So real quick, I had a question I'm going to answer. Someone asked, many veterans, especially enlisted, have more than one discharge certificate. Does any honorable or general discharge make a veteran eligible, or just the last discharge? The answer is, of course, it depends. But usually if you have a period of honorable service for which you got a DD-214 and your other discharge is not too negative, the answer will be yes. And that's a character of service determination made by the VA is done on a case-by-case basis if your paperwork doesn't always say honorable. But usually they will consider that enough to have a positive character of service, even if, for example, you got a other than honorable for disciplinary infraction on a second enlistment or out of the reserves or something like that. So the D-214 is your farewell slip from military service. Every veteran gets one on the way out the door, unless you go AWOL, in which case they'll send one to your last known address. So you are always going to get these. What they are is kind of a summary of your military service for use in applying for benefits. So it's kind of like a military-styled resume. There have been a bunch of different versions of this form over the years, so they all look a little bit different, but they all kind of contain the same information. For the purpose of what you would do with it in determining whether a veteran may be eligible for something or not, You're looking for each of those four things that Diana was talking about. We've got the branch of service up top, the length of service, character of service, and I consider discharge narrative in there because that will often give you some insight if the character of service is not honorable or general, whether they, what they need help with next, because it will say in there, for example, misconduct, or it will say, I mean, if you've been medically discharged or medically retired, it will say that on this form too. So it will kind of give you an idea broadly of what the veteran will qualify on there. These are also kind of useful shorthand for what a veteran did in service, which may help you make the case otherwise for why their service should be considered positively characterized. If the VA denies a positive character of service determination, having stuff like combat deployments will help make the case. Having a decent decorations and medals branch will help the case to say, I had a really good service period and then things went poorly after the deployment. That's something that the VA will usually take into consideration and then approve relative to someone that gets in, serves a few months, isn't particularly good at it, is a poor fit for the military, and is discharged. So there's some other information you can glean from it, but I'll take you a while to get used to seeing these and to what you're looking for. One caveat I would say, true for my D214s and a lot that you see, there's mistakes on these. So these are not always accurate. If it's important for the particular benefit they're applying for, you can make corrections to these. If you have the paperwork, you need to correct it. For example, there's an award missing. It's relatively easy to do. If you're asking for them to make more significant changes, that's something that's going to be covered later. But I'm only saying that as a caveat to D214s are good sources of information, but they're not always correct. That's pretty much true of any military paperwork. So we've established, next slide, please. So we've established the entitlement for basic VA services, and that means that you're qualified for VA benefits. That doesn't mean you're qualified for any particular VA benefit. Now you have to apply for the specific one you want. Next slide, please. So I'm going to cover almost all the benefits in just a few minutes here. These are what I call the easy ones. It doesn't mean they're easy to get. It certainly doesn't mean they're easy to earn, but it means that there's not a lot of lawyer work put into getting these. Normally, your D214 presented to the place that can give you this benefit is sufficient. And if you have those boxes that have the correct information in it, the place that will provide that to you will give you the service. So this covers the GI Bill and the Hazelwood Act for educational benefits or for vocational rehabilitation benefits. Every school that takes these benefits has someone on staff whose job it is to take your paperwork and to go to the VA and get your money. So it's not something that you usually need representation on or help or assistance with, because there's somebody that works for the school who is financially motivated to get you the benefit that you're entitled to. And that person hopefully has enough expertise that when you present them with a D214 can tell you, yes, you're probably going to be eligible and I can file the rest of the paperwork for you. That's all you had to do to get it. Just so you know what the GI Bill is, and it's recently gone through some changes, but the GI Bill is the way that the military pays for college after your discharge. So for honorably discharged veterans that go to state schools, they will theoretically pay 100% of the tuition, and there is a stipend that comes along with that, depending on where they live and what the cost of living there is. For veterans that aren't eligible for the full GI Bill because they didn't have that extended period of service, I think you have to do 3 years to get the full amount. It just reduces the amount that you get for that. The Hazelwood Act is an act in Texas that waives tuition at state schools. The caveat to using the Hazelwood Act is you have to have exhausted all of your federal educational benefits first. But for someone attending a state school that has exhausted the GI Bill or is otherwise not eligible for it, if they entered military service in Texas or they exited military service as a resident Texas, they are eligible for a tuition waiver at state schools. There are a lot of different vocational rehabilitation programs as well. Those are administered through the VA, so they can be a little bit more difficult to get, but the qualification process is the same mostly for the GI Bill. The GI Bill is the most commonly used benefit that veterans receive and use. Almost all veterans that are eligible for the GI Bill end up using it in one way or another. So it's a very frequently used benefit compared to the others. The second most used one is the housing benefits. Like I said, the VA gives home purchasing assistance, which is a guarantee on the first $30,000 on your mortgage. So what that means is a private company will give you a mortgage. The VA guarantees that if you default on the mortgage, they will pay $30,000 towards the mortgage. And what that has the effect of is that most veterans can purchase a house without needing a down payment. So it doesn't give the veteran any money. It doesn't give them any more qualification for a better loan. What it means is that they don't necessarily need down payment, and they're going to look like a more attractive purchaser than someone that didn't have that guarantee. The downside to that is there's quite a bit of paperwork involved, so some veterans don't use that if they can otherwise afford to skip it because they have a pretty intensive inspection process. It can only be used for a house you intend on living in, so somebody has to come out and inspect it and say that it's sufficiently good to live in, but they have a lot of old and weird qualifications to what a house is good enough to live in. So you can't use it really to buy a fixer-up or something like that. The other ones are the homeless and the HUD-VASH voucher program. This has changed a little bit since I've been involved in the program, but what it's designed to do is that for veterans that don't have a place to live, instead of going through the normal process that the HUD has for getting someone housing assistance, which there's a limited number of vouchers they can give out, they're not as limited and they can get them much quicker. So with a DD-214 and proper eligibility paperwork, a veteran can get housed very quickly in transitional living if they have the right paperwork. So this is kind of a benefit that you hope never to use, but it does, it is obviously imperfect, but significantly better than the civilian equivalent. Medical benefits, so veterans are eligible for healthcare through the VA. They get healthcare by applying for it. Veterans that are retirees or have service-connected disabilities will automatically be qualified for those disabilities or retired for everything. A certain level of disability will mean you're eligible for everything as well. If you have a less significant disability, then you'd only be covered on that. In addition to that, veterans that don't have health care from any other source that cannot afford health care otherwise can be covered by the VA, but they have to apply for that annually and give a certification of no other source of income. No other source of health care and no other source of income. Additionally, veterans that are eligible to use the VA but have healthcare from other sources can still use the VA hospitals as medical service providers, and they can bill your private insurance or they can bill Medicare. For the medical benefits, that's not true for every veteran. So the rules wouldn't be the same. You have to go in, give them your D-214, apply, and they will tell you what you're eligible for. They have different priority groups that every veteran fits in, and they are required by law to serve some priority groups, and some of them are optional depending on capacity and need. So it can change from year to year whether a veteran is eligible to use them as their kind of full service healthcare provider, or whether they have more limited services available, or whether they're not eligible this year. Typically, it is something that doesn't involve any litigation, though, because it's something that the VA looks at your paperwork for and says you fit in this priority group, and this priority group is what we're doing this with right now. Last one is funeral services. So every veteran is entitled to a flag and a color guard at their funeral. If a veteran wants to and they have the correct discharge, they can be buried at a national or state cemetery. There's a national cemetery in Houston. There's quite a few state cemeteries around Texas. The eligibility for being interned at one of those is determined upon veteran's death, so you cannot pre-apply. So for certain cemeteries, there is a eligibility criteria. Like if you want to be interned in Arlington, you have to have a impressive resume, whereas Houston has plenty of space. And if you choose to be interned there, they provide you with a headstone. There's no cost to the veteran or their family once they have to get the veteran from the place where they passed away to the funeral, to the cemetery, and everything else is covered by the VA once that is done. Next slide. Okay, so we're going to talk about service-connected disabilities. I'm going to check the time right now. Is it okay? I said we're going to take a break at about the hour mark, but since this section kind of goes continuously, can we take a 5-minute break right now? I don't know who I'm asking that.
That's a good idea. Let's take a 5-minute break.
We're going to get started in about 2 minutes here. Really impressed with the turnout. I've never been muted by more than 100 people at a time, so that is really good. Thank you all for being here, whoever's listening.
Andrew, I'm ready to see or hear the Andrew Lehman Military Humor podcast. I expect it to start up soon.
I am yeah, I got else to do, but, you know. Actually, this is not something I found online. This is a picture I actually took. So I'm standing at the other end of this camera, screwing down with explosive ordinances.
Well, I wasn't representing the picture. I was talking about the
Oh.
being on mute by over 100 people.
Okay.
I was gonna say something if you were an officer because I was enlisted, but I won't.
Why do you think I'm an officer? Wait, don't I have? Don't I have my NCO created in my stripes above my desk here somewhere? Got to zoom in to see that one.
I was gonna say if you were an officer, you'd already have been muted by more than 100 people at some point.
No, I had the misfortune of being the officer whisperer because I seem to have a way of talking to them that they found it more appreciable than most NCOs. So I could try to talk them into things that they, you know, whenever the good idea fairy rears its ugly head to say, well, sir, that's a strong idea, but think about this. Okay, so it's been 5 minutes, so I'm going to get started here again. So the kind of meat and potatoes, the absolute part that we don't want to miss here is to talk about VA disability compensation, because almost all the problems you're going to hear on a veterans clinic or when trying to help veterans is going to be built around VA disability compensation for service-connected disabilities. That is the most common one where veterans have a problem. When you hear about veterans waiting years for benefits, this is what they're talking about. When you hear about veterans struggling to make by on the amount they get, this is what they're talking about. When you hear about veterans needing assistance from agencies or organizations with the VA to help them, this is almost always what they're talking about. So this is the one we're going to focus on the most, because if you're going to try to advocate for veterans as a lawyer, this is the one that you are most likely going to be asked to do, and this is the one where you can most use your skills as a lawyer to help veterans. So what VA disability compensation is the amount of money that a veteran receives every month because the VA has determined that something that occurred in your service is causing you a current disability. So when a veteran applies for disability, they have to show that in general their character of service makes them eligible. We talked about that. They have to have medical records that show that they are currently disabled at the point that they're applying for the benefit and going forward. And they have to establish a nexus between their current disability and something that occurred in military service. So anytime a veteran's application for service-connected disability is denied, the VA has decided one of these elements is not being met, and the onus is on the veteran to persuade them otherwise. Next slide. Anything that occurs in military service that causes an injury that is not either a willful misconduct or in general something you shouldn't be doing is going to make you eligible for service-connected disability. So something like being injured in combat is the obvious one, but almost all service-connected disabilities where the veteran has a problem establishing the connection, it wasn't something that obvious at the time. So the stuff that you can't qualify for would be considered misconduct or would be considered the fault of the veteran. For example, if you shoot yourself in the foot intentionally, you're not eligible. If you shoot yourself in the foot accidentally, you might be. If you get in a car accident while you're driving drunk, you're not eligible. If you get in a car accident and you were sober, you may be eligible, even if your driving car had nothing to do with you being on duty at the time. If you are on federal service and you're on active duty, anything that happens, you're always on the clock, so anything that happens is considered as part of your military service. Service-connected disability is rated on a scale from 0% to 100% in 10% increments. So you'll sometimes hear veterans say something like, I'm a 100% disabled veteran. And what that means is they've maxed out the scale for how much the VA will compensate them. The VA pays a different amount from 0%, which is nothing, up 10%, which is about $175 a month in that range, up to $3,000 a month at the 100% range. And that amount varies a little bit depending on dependents and other factors, but there's a big jump between 90% and 100%. So for a veteran seeking a service-connected disability, there's almost always the incentive to get to 100%. Intuitively would say if you have a condition that disables you at 10% and a condition that disables you at 50%, you are 60% disabled. That is how humans do math. That's not how the VA does math. They use a much more complicated formula than that. So it's not always easy to tell from someone's disability rating necessarily how disabled they are, or from what someone's disability is, what rating the VA is going to give them. The compensation is a monthly compensation for how the disability affects your day-to-day life. So it's not like a personal injury suit where they're saying, you know, we did this harm to you and here's your compensation for your pain and suffering and for the years when you couldn't, you know, walk or something like that. It is from the month that you apply going forward, this is how the compensation is going for how this is affecting you on your day-to-day life. You have to show service connection. So the problem with that usually is that military medical records are terrible. The veterans don't keep their records. They're handed kind of a pack on the way out the door, say, here's all your service records, and then they go away and they don't necessarily keep track of them. So it can be difficult to establish that connection between something that occurred in service and a condition that may pop up years later. It's particularly true for things that weren't going to produce necessarily any paperwork at the time. So if you think of something like a mental health condition like PTSD, it's unlikely whatever triggered that as part of your military service produced anything in your medical records. That at the time of the incident you said, oh, this is causing me mental health problems, I'm not gonna be able to sleep for the next 10 years. So those aren't always going to be clear connections. That's why part of the advocacy process is figuring out where should there be a record of this and what can we produce to create a record of this. The veterans' personal statements, affidavits, and witness statements are considered evidence for this purpose. There's going to be some exceptions where that's not going to work, but basically for any circumstance where there's not going to be an official record and it's plausible there isn't one or there shouldn't be one, then a witness statement or a personal affidavit can be sufficient evidence. Next slide. So service-connected disability is very different than a civilian kind of version of this in Social Security, or I think the common use of the word disabled. So service-connected disability does not mean the veteran cannot work. The veteran can work. There's some exceptions, but for the most part, if you're service-connected disabled, you can have any job you want. It doesn't mean that they're disabled for the purposes of Social Security. The Social Security Administration has a different definition of disability than the VA, and they don't necessarily overlap, and it would be perfectly consistent with the rules of the VA to say a veteran is disabled, and the rules of Social Security to say the veteran is not disabled, and both of them having followed the law correctly. There can be some disabilities which are not significant or obvious. So a lot of veterans get disability ratings for things like hearing loss, which is of course very common. And that kind of disability would get you a 10% rating and you can't hear very well, and that's it. You go through life just the same as anybody else would, and unless you tell somebody, they wouldn't necessarily know that's something you're receiving compensation for. There can be a 0% rating, which means that the VA acknowledges that there's a condition, but says it's not disabling at this time. And the compensation, the amount they give you is for after treatment. So what this means is if the veteran is not necessarily compliant with their physician's recommendations, this is particularly an issue when it comes to medication, the VA won't necessarily know how to rate them or won't necessarily rate them as high as they should if they're not a compliant patient. So they have to follow their medical guidelines with that as well. This can come up, again, particularly for mental health issues where veterans don't like the effect the medication has or would prefer to do some self-medication that's not necessarily legal in the state of Texas, and the VA won't acknowledge that as being compliant as them as a patient. Next slide. So for veterans that are getting out of the service for the last probably 10 or 15 years, some of this stuff may not apply. The VA and the military have become a lot more aggressive about trying to catch veterans out of the door to apply before they exit service or immediately after they exit service, because all the records are fresh. They don't have to track anything down. But in general, if you're getting out of the military and you have a service-connected disability, you must apply. They're not going to come to you and say, well, remember that thing that happened that we think caused you an injury or all that stuff you saw treatment for at the time, we're going to compensate you for that. This is different than someone who's medically retired from service, which is a whole different category that we're not going to talk about today. But that's the military saying that you are hurt in service and you can no longer perform your job, but it's our fault and we're going to go through a process of getting you out of the military, but consider you medically retired. For VA disability compensation, generally that process has not happened and you're getting out of service and applying for the first time once you leave. Your compensation will go back to the date that you applied and were approved. So if, using my examples on here, I feel like every time I use these examples, I mess them up. So I'm going to read directly off what my examples are. If you apply on January 1st, 2000 and are approved in 2013, that application gets 13 years of back pay. If you apply in January 2012 for a disability you have records for going back as far as 2002, and you get approved in the same January 2013, you're only going to get a year of back pay. So they can't go as far back as the injury. They can't go as far back as you having sufficient evidence of the injury. They can only go back as far as an application that was approved. And I say an application that was approved because if you apply and are denied and don't appeal it, and that application is considered done, and then a year later apply again and get approved, they're only going to go back to that one that was approved. They're not going to go back and look at that earlier application that wasn't appealed. These are important things to know if you're helping veterans with this, because they will be mad about this because it doesn't make sense, it's not fair, and it's not what they do in the civilian world. So these are rules Congress created, and Congress can change them, but there's nobody else that can get in between that right now. The VA doesn't have the authority to change that or to approve that. As with everything else, there's some exception for this, but that's complicated stuff that we're not going to get into today. Next slide, please. So what happens after you apply? Well, the VA reviews the application. They do it at the regional office across the street from the VA. Typically, it takes a long time. There's a lot that get rejected in less than 90 days, but that's more recent. Turnaround time is not always that good on these. The reason that the turnaround time isn't always good is because your application doesn't need to include all of the details or all of your records. The VA has the responsibility to get records that are in their custody or in the custody of the federal government and the Department of Defense. So what they do when they get an application is they say, okay, we're going to go to the VA and get all your medical records, and we're going to go get all your service records, and we're going to wait for them to come here and then look through everything and decide whether you're disabled or not. So of course, it's going to take some time. The VA often requires more medical examinations called a compensation pension exam that we're going to talk about a little bit later. And then they issue a decision. So they can approve the application at any rating between, let's just say 0 and 100, 0 and 100%. So if the veteran gets approved for disability but is unhappy with the rating, so they got rated at 10% when they felt it should be 100, they can still appeal that rating. Or the VA may deny the application and the veteran can disagree and appeal. So as you can see, all roads lead to appeals. The rejection rate, the last time I looked at it, which admittedly was a few years ago for initial applications, was close to 90%. So I don't think that has changed significantly. I still imagine it's pretty high. So almost everybody that goes to that initial application gets rejected. I'm going to look at the Q&A real quick before I move on to the next. Okay. Justin, do you want to answer that question on Agent Orange while I read the other two? Oh, never mind.
I see a question about the military hospital records. Do you request them directly from the hospital or the VA? So depending on what branch of service and when you served, your military medical records can be located in different locations. After a certain amount of time, the military started to send all military medical records to the VA. So a lot of them should be available and you can request them from the VA. I have also requested them directly from the hospital. They would prefer that you attempt to get them from the VA first, if that's where they are, before you request them. But yes, I have requested them directly from the hospital and gotten a response and gotten the records. Now, to find out where your military medical records are, or where your client's military medical records are, you can look on a form called the SF-180. That is the form that you submit to request military records. The form has a box at the bottom. It breaks up each branch of service, years of enlistment, and it will tell you, it will give you the address of where either your official military personnel file is located or where your military medical records are located. And that's a really good guide. The form, again, is called an SF-180. That's a really good guide to look at when you're trying to determine where to request military records.
Okay, so there's a question that says, how difficult is it to locate medical records from 20 or 30 years ago? If they're VA records, the VA doesn't throw anything away. They lose things sometimes, but they don't throw anything away. If it's military service medical records, that depends on how good your unit custodian kept track of the records and moved them around with you. So same thing, they're not supposed to throw them away, but those kind of records are much more likely to get misplaced because they go through a lot more custodians and they move around a lot more. So it depends on who you're trying to get them from and where they are. It's not uncommon for stuff that was lost to make a reappearance many years later because whoever was supposed to find them the first time kind of did a cursory search and didn't really look, but somebody gets in there and really looks and ends up finding them. But that depends on the type of record. So there's another question about whether Agent Orange is eligible. The answer is yes. Agent Orange is actually one of the easier ones to prove because proving service connection only requires proof that they were in Vietnam at the time, at any point during that time, and that they have a condition that's listed on kind of a VA presumptive service-connected list. So there's a list of medical conditions which the VA says if you spent 1 day in Vietnam or one of the surrounding countries, and you have any of these conditions, we assume it's service-connected and we assume it's our fault. If they didn't spend time in Vietnam, then they would need to show that they had personal exposure to Agent Orange separately. And if they don't have one of those presumptive conditions, then they would have to go through the normal process of getting a physician to say, this condition is, in my opinion, related to their military service and is more likely not caused by their military service or their exposure to Agent Orange. Any recourse if they simply can't locate the records. So there's a type of document called a C file, which you can request, which is supposed to be everything the VA has on them. And that should include any medical records that they can find. There's not really a simple answer to this because it really depends on where you're trying to get the records from. So, like I said, you don't have to go through the kind of big VA to try to get them. You can try going through the place that should be the custodian of them. If that is military records, that can include the unit itself and what they would have done with them. Yeah, somebody said in the bottom you can request it via Freedom of Information Act too. It is weird to request your own records via Freedom of Information Act, but it goes to the custodian of the national, your national records as well, which may have things that the unit didn't have if they're military records. If they're VA records, again, you can go straight to the hospital, straight to the administration. They're not going to let you go through their files, but it's one of those things where, you know, if you're a squeaky wheel, they're more likely to give a real search for it than a cursory check by that name. So I think there's some questions coming up in the chat, and if you can put it in the Q&A so I can see it in there, that's great. Otherwise, I'm going to move on to death and indemnity compensation. Let me see. Okay. Attorneys can charge a fee. Well, okay, somebody answered the question. Oh, I was typing. Okay, thank you. Okay, moving on to death and indemnity compensation. So this is for the survivor of a veteran that has passed away. If that veteran passed away either in the line of duty or from a service-connected injury or disease which contributed to their death. It's a monthly benefit paid out that is tax-free. Eligible survivors could include the spouse, the minor children, and in some cases, the parents of the veteran. Next slide. So in order to qualify for death indemnity compensation, we go into a little bit more detail here because unlike the veterans benefits where the veteran knows about their service, when you're dealing with a spouse, they often don't know a lot about their service. So this is one where you can frequently kind of have a blank slate from the person you're talking to. They know their spouse was a veteran. They want to know whether they're eligible for anything. They don't know anything else. So circling all the way back to the D214, this is where the D214 is really important because if you can look at a D214 and know the basic eligibility for death indemnity compensation, you can say that they have eligibility if their cause of death meets it. So what does the cause of death have to be? While on active duty training or inactive duty training, which is basically when you're on reserve duty doing your weekend drills. Like service-connected disabilities, it doesn't have to be something that was supposed to happen to go wrong. So things like car accidents and training accidents happen would qualify, including car accidents, driving home after from the post at the end of the day. You're still considered on active duty, and that's part of your service. Again, anything short of willful misconduct will usually qualify. For this service-connected disabilities, it means that they were receiving service-connected disabilities for one of the causes of death. So where's the important part here? You need to know what they were receiving service compensation, service-connected compensation for, what conditions the VA thought they were compensating them for, and what the coroner thinks their causes of death are. So sometimes this lines up nicely. You have them getting compensated for hypertension. You have a cause of death, heart attack. Those connect pretty easily. But for the widow, the surviving spouse, they may not necessarily know what they were receiving VA compensation for. They may say, well, he was receiving something from the VA, but I don't really know what it is. And that's why those that awards letter is something that the VA sends out every year. So every year, if you're receiving VA compensation, the VA sends a letter to your address and says, you are receiving VA compensation for these conditions, and this is the amount you're receiving. So hopefully they'll be able to track that down. Otherwise, they can, of course, use the death certificate to request from the VA regional office information about what the veteran was receiving compensation for. For veterans that were 100% service connected, that was totally disabling, and they were considered that for 10 years before their death, regardless of what their cause of death is, they would be eligible for death indemnity compensation. So what does that mean? Veteran gets out of the service, is rated 100% disabled, lives 10 more years, and dies in a car accident. Their spouse would be eligible for death indemnity compensation. If you take the exact same circumstances and the veteran is rated 50%, then the spouse would not be eligible for anything. Next slide, please. Okay, the service connection has to be related to one of the causes of death. So the I think I already spoke around these. I mean, I've got a little ahead of myself, but I'll just run through the slide again real quick. So the disability death was service connected, and the veteran's principal or one of the contributing causes of death. It's like said on the death certificate has to match. There can occasionally be issues where the spouse is unhappy with what the coroner found. That can be a legal problem, but is totally outside the scope of what we're dealing with today. Again, in service is presumed to be service connected if it occurs in service, regardless of what the exact circumstances are, unless it was the veteran's fault. If the veteran would have been eligible for service-connected disability, but was not approved. So that means they either had a pending application that is later approved, or they hadn't applied yet, but they have sufficient service records and medical records to show that they would have been eligible if they had applied. you can still get it as if they'd received it. So let me give an example, unfortunately, it's what I'm dealing with right now, where I had a veteran who had a pending case for disability, and the veteran recently passed away. That application had not been approved yet. If it is approved, she will be able to apply for DIC. If it is not approved, we can still keep that application going. And then she would be eligible for that compensation he would have received while he was alive, and be able to show the connection for death indemnity compensation. So even if a veteran wasn't receiving any compensation for a service-connected disability, if they can prove that they would have been eligible for it, they can still receive death indemnity compensation. Next slide, please. So now we have to define a spouse. So the marriage to the veteran has to be valid in any of the following: the place the couple currently resides, or they got married, or resided when the benefits arose. So this has gotten a little easier over the years because marriage laws are not that different between states as they were maybe a few years ago. But any of these is enough. So if they were married and they're none of the examples are particularly favorable, but this can often come up if they were married overseas and they don't necessarily have a marriage certificate that you would normally recognize. But the marriage, when we're talking about valid marriage now, the gay marriage is legal everywhere. This really only falls into examples of what some states would consider divorced and what some states would consider too close a degree of consanguinity. The spouse is required to prove that they were married, though. So marriage certificate is obviously what you want in Texas, because Texas has common law marriage. If they were married in Texas or resided in Texas, they could prove that as well. Usually the VA will believe it if you meet the basic qualifications for common law marriage. If you don't, you'd have to go to court to get a declaration of common law marriage to prove that eligibility. The spouse has to be married to the veteran at the time of the death. They have to have been married for more than 1 year and have lived continuously from the date of marriage to the date that the veteran died. There are exceptions to that if the veteran disappears or abandons the spouse, but that's on a case-by-case basis. And the spouse is not remarried or cohabitates with someone that they would consider a spouse. I believe that we're only going over the broad of this. There are exceptions for all of these rules that may apply to your specific situation or a specific veteran or widow that you're speaking to. So if they don't meet kind of the bright line rules, then there may be an exception they qualify for. A lot of the exceptions have to do with kind of legacy processes that used to exist before the current DIC. So don't take any of these as determinative. For example, if they've received DIC for an extended period of time and then get remarried, in their 60s, they may be eligible to continue to receive the DIC even though they're remarried. Next slide. So the veterans make a lot of mistakes getting married. This is almost entirely the military's fault, because the military doesn't acknowledge girlfriends. You're either single or you're married, and there's nothing in between. You can't cohabitate. You can't have any sort of relationship with anybody unless you're married. If you're married, you get housing and other kinds of benefits for you and your spouse. So what this does is create a situation where young soldiers have an overwhelming incentive to get married as quickly as possible to get out of the barracks and get more benefits. So that is frequently a problem for divorces, not necessarily for VA benefits, but it does matter because what you don't see, unfortunately, frequently is veterans that get married while they're stationed somewhere, and they don't get properly divorced, and then they come home and they may get married again. Then the other situation you see is that they get into marriages they shouldn't, and they don't necessarily cohabitate. So it can bring up a lot of issues because getting married is a lot easier than getting divorced. Next slide. Okay, so we're going to talk about eligibility for surviving children. I'm starting at the bottom first. So child includes biological, adopted, and stepchildren. So stepchildren is a little unusual for a lot of benefits they would consider a child. So that's one to keep in mind. One of the caveats is that the child is not included on the surviving spouse's DIC. So there can be conditions where a stepchild would be eligible from a previous marriage and a current spouse be eligible for DIC. So they can't overlap. They have to meet the same qualifications for dying in the line of duty or service-connected disease. The child has to be unmarried and usually under the age of 18 or up to the age of 23 if they're attending school, or if they're a disabled adult child, that benefit can continue indefinitely. So what that means is they have to be diagnosed with a disability before they become an adult, or their adult disability has to be traceable to something that occurred in childhood for them to be continuously eligible. There are educational benefits available, particularly to children of veterans that died in the line of duty that do not overlap with the DIC. So if a veteran's child is receiving a benefit through that program, they cannot receive DIC at the same time. Children are independently eligible for this, irrespective of their parents. So if the veteran had children that were outside of the marriage, or their spouse is eligible for their full amount of DIC, and their child outside of the marriage is eligible for the full amount of DIC, they don't have to share and they don't overlap. There's not a limit to this. If the veteran procreated very prestigiously during their life and passed away in the line of duty, there is not a limit to the number of children that can be eligible. So this isn't a finite benefit that has to be shared amongst beneficiaries. It is independent. Like I said, the only limitation is if you're the child of a veteran who's eligible, but your parent is receiving the benefit, then you are not also eligible. Your parent will receive more money, but it's not double. It's not two separate eligibilities. Next slide. In rare occasions, parents can be eligible for this. And basically what you have to establish there is that the parents were financially dependent in some way on the veteran. This isn't that uncommon, but the VA determines that by what the parent's income is. So if the parents have an income that's below the poverty level, they can be eligible for DIC payments if the child dies in the line of service. This isn't something that comes up very frequently, but it's the only one that's income or means tested. If you're the spouse or the child, it doesn't matter how much money you have or how much income you receive, that benefit, you can receive that anyway. That income limitation only applies to the parents. Next slide. So to avoid over confusing you by explaining what a survivor benefit program is, it's basically something they try to sell veterans that says, or active duty service members or reservists, that says this will take care of your spouse if you die. And it will. The problem is doesn't overlap with DIC. So the VA will look at the amount of money they're receiving from that program and from DIC, and whichever is greater is the one you'll receive. Why is that a problem? Because the annuity, this SPP program actually costs them extra money. So if they pay into it and then the spouse becomes eligible for DIC, the spouse might say, hey, why did I pay for this benefit that I'm not receiving anything for? It's not fair. They are right. That's what the law says. Like I said, Social Security does not matter for DIC benefits, so they may be eligible for Social Security as well. This is true for minor children of a veteran, where Social Security will pay a benefit if one of the parents is an earner passes away. That's its own benefit. They can receive both at the same time. Next slide. Okay, how are we doing on time?
We've been going almost an hour and a half. We have quite a bit left. So we may need to speed things up a little bit.
Okay. Okay, so it's your turn. I'm going to skip ahead and cut some slides. We can cut the comics too. We don't have time.
All right, I'm going to jump in. We're going to talk about the VA claims procedure. So we've gone through and talked about benefits that veterans can, or their spouses can qualify for, DIC, service-connected disability, and this is going to discuss, how they apply for those claims, and then eventually how they appeal those claims if they're denied, or if they disagree with something, with a determination within them. All right, so we've been talking a lot about requesting records, or what evidence you need to qualify or meet the eligibility requirements, what you should submit. So I've inserted a chart here that I found helpful that lists what you're seeking and how you can request it, right? So we have the C file, which Andrew touched on. We have military records, medical records, and then private medical records. So if you want the C file, there's a particular form listed here, VA Form 3288. And as someone mentioned previously, you can also do a Foia request. That form, you're going to send the Foia requests, Form 3288, you're going to send that directly to the regional office. Military or medical records, I touched on this earlier, you have an SF-180, and I mentioned that those boxes on the SF-180 on the second page, that's going to list where you need to send the form depending on what branch of service, and what branch of service, and the years that you served. VAJ medical records, you want to send those requests directly to whichever medical facility provided the medical care to the veteran. And then you have your private medical records here. And if I was a personal injury attorney, so I'm particularly familiar with this. You have your HIPAA request, and you submit that obviously to the private doctor's office, and it can be a lot. Requesting these records can take a long time, so I always tell my veterans to request them as soon as possible and get it, because you'll have to wait, especially from the VA. I've submitted requests for C files, and it's been a year, and I still don't have them. So make sure you do that as soon as possible. That's really important. Next slide, please, Robert. All right, so to make things more complicated with the VA, they passed a new law in 2017, and it really benefits veterans. It was a good law, but the problem with it is that process, which we're going to call the modern process, the modern appeals process, is running concurrently with the old process, the legacy process, right? And so that can cause confusion for a lot of veterans. So we're going to talk about each of them separately, so you understand both of them, because the legacy process, there's really no end in sight on when those claims are going to die out. They're going to be around for a long time still. So it's important to understand both. The old process, the legacy process, applies to VA decisions that were received before February 19th, 2019. If you received a decision February 20th, 2019, the process that applies to you is the modern appeals process. Next slide, please. All right, so how does a veteran apply for benefits under the legacy process? They file what's called an intent to file. This is not the actual application. This is simply a way that the veteran can place hold their time to receive benefits. Andrew mentioned earlier that you start receiving benefits from the date of your application, right? So the intent to file was really encourage veterans to file. You file the intent to file, and you have a year to file your application. So a year to get all those medical records together that we talked about, a year to get your military records. And if at the end you submit your application and the VA approves it, you would get benefits from that intent to file, from the date of that intent to file, not the application. So the veteran would file the intent to file, right? Then they'd have a year to file their formal application. If you do not file that application within that year, then your intent to file expires and you would have to start all over again, right? So let's assume for our sake that they filed the intent to file and they've filed their application timely. After a veteran applies, the VA will schedule something called a compensation and pension exam. That is not necessary. It's a discretionary requirement, but the VA, I actually haven't run across a client that has not been scheduled a compensation and pension exam. So what that means is the veteran attends this compensation and pension exam and is examined for the benefit that they're seeking. So service-connected disability, you're saying, I hurt my right knee when I was in service, and it affects me day to day, so I should be compensated. So you apply for that benefit. Then the VA is going to send that veteran to the doctor to get examined, and that doctor is going to make a determination on if your disability is current, how severe it is, things like that. Once that's scheduled, and once the applicant attends, the VA makes a determination on the benefit, right? They will mail the determination to the applicant, letting them know, yes, we approved your service-connected disability, or no, we've denied it, or yes, we've approved your service-connected disability at 20%. And we're going to talk later about appealing those different decisions, but next slide, please, Robert. Thank you. I like this graph. I'm a visual person, so it's easier to see here. We have the intent to file the 1 year to file your formal application. And then you'll see here onto the side, it says VA schedules compensation and pension exam. Like I said, that's discretionary. And then during that same time, they're going to review the claim. They're going to review your evidence. They're going to review your application, your military records, and then come to their decision. They mail that decision. If the veteran's unhappy with it, they can appeal it, which we're going to talk about next. And these are appealed under the legacy system. Next slide, Robert. Okay, so what happens when you get an application, or excuse me, you get a VA decision and you disagree? You disagree that your disability is only 20% rated, you think it should be higher, or they just denied you outright. What would a veteran do? They have 1 year after the date of that decision to file a notice of disagreement. And when they file the notice of disagreement, they had two choices. They could either seek DRO review, decision review officer is what that is. They can request that the DRO review their claim, which is a completely new review, de novo. They look at it with no regard to the other decision, and they can request a hearing if they want. Or they can just ask for a re-review. So another person at the VA to review their claim and make a determination. If after the DRO review, or if you just do the traditional review, the VA is going to issue its second decision, which is called a statement of the case. That statement of the case, they're lengthy. They can be up to 50 pages, and a lot of those is just listing out the statutes. And if you can imagine, if you're a veteran and you get this 50-page statement of the case, how confusing that's going to be and stressful, right? So I always try and tell veterans when I'm giving them advice and counsel, take a deep breath, try not to freak out, because a lot of times veterans come in and they're frustrated, first of all, and they don't, the old statement of the cases especially, they don't do a good job of explaining why they were denied. That's changed under the new process, and Andrew will touch on that. So let's see. All right, so you get your statement of the case. The VA decides to continue with this decision. Let's say, oh, we still think that you're 20% rated, or, oh, we're still denying you your service connection. The veteran has 60 days to file a Form 9. The Form 9 is not the actual appeal. What it is just notifying the VA that the claimant is appealing. And the VA receives the Form 9 and then certifies the appeal and sends it to the Board of Veterans Appeals. that was pretty confusing to me at first when I first started out. I thought, oh my gosh, you only have 60 days to file your brief and additional evidence arguing with, the statement of the case. That's not what that means. It's simply a form that you submit to the VA, just notifying them I'm appealing. And that's a hard deadline, so make sure, that that's not missed. Once the VA certifies the appeal, sends it to the BVA. The BVA can hold an informal hearing if the veteran chooses to have one, and, reviews the claim, reviews the C-file, reviews the packet that was submitted. And then they make their own determination, right? They can deny the claim, basically agreeing with the regional office. They can grant the claim, relief for the applicant, or they remand the claim back to the regional office. Perhaps records weren't requested that should have been. Maybe a veteran references a doctor in in the brief that that he or she filed, and those records aren't in the appeal packet that the BVA got. They can remand the claim back down to the regional office for them to gather that evidence so that the claim is complete when it's being reviewed. Next slide, please. So under the legacy system, once your appeal is certified and it's with the BVA, the claimant can submit new evidence all the way up until the decision is made, all the way up until the BVA makes its decision. However, there is a caveat to that, right? If you're submitting new evidence to the board that the regional office has never seen, the board is supposed to, actually must remand that case with the new evidence back down to the regional office for review. I have the statute listed here. That is actually a statutory requirement that they remand it upon receipt of new evidence. However, you can waive this, and it's really sometimes it's in the interest of the veteran to waive it, because remanding a claim all the way back down and having it reviewed again and sent back, that's obviously going to take a long time. So how do you waive that? How do you waive that requirement that they remand the claim? You just submit the new evidence with the letter explaining that you're waiving your right to the initial review. There's no form, there's nothing, there's no official words that you need to use, just that you're waiving your right to the initial review by the regional office. Next slide, please. Now this is an older depiction of the legacy appeal system here. I think it's 2017. I included in here to give y'all an idea of how long the legacy process took. More than 4 years. This is an average timeline, right? So it took more than 4 years to go through this entire process that we've just talked about. And that process being initial application, notice of disagreement, appealing the statement of the case, having the BVA review it, and then make a decision. So to make the claims process go faster, the Congress passed an act, and Robert's going to talk about that in a little bit, but which implemented the modern system, and like I mentioned earlier, makes the claims process, the appeals process, much more quick for veterans. So Andrew, if you want to talk about that.
Next slide, please. Okay, so we told you how bad the legacy system is. The good news is the 1-year appeals window has ended for any claim under the legacy system. So hopefully, if you're doing this for the first time, you've never touched a claim before, you can only need to learn the new system. The old system is old. If you get a case that comes from the old system, move into the new system. So the problems with the legacy system, I think, boils down to the top bullet, which is it was designed to avoid lawyers. It was designed not to be an adversarial system. And the result was that the VA played the role of the plaintiff's attorney, defense attorney, the judge, the jury, expert witnesses, and the appeals court. And then they said at the end of that, they sent the veteran a letter that said no and didn't really explain it very well. And you can imagine the effect that had on the veteran, feeling that they were advocated for. The VA was on their side and had a duty to assist them. So then the new system is better for lawyers because it gives more opportunities to advocate. It gives more opportunities to use the system to work kind of like a regular civil case would work. And because it puts the pressure on the VA to provide more information about what decision they're making, why they're making it, what they're looking for, what they like and they don't like. And then obviously the timelines are supposed to be faster, and one of the ways that they're doing this is because they're going to create different lines that you can go into now. So before, all disagreements went through the same line. So if you had a technical point of order, you're going the same line as the person that said, oh, here, I found my 10,000 pages of medical evidence. And you're behind that person in line. So now they've given us an express lane, a self-checkout counter, and the old line you can still get into if you want. Next slide, please. So the major changes they made is, like I just said, you can choose your own lane. All of these appeals now take place at the local regional office. They're supposed to include on the decisions details of the evidence that was considered, finding favorables to the veterans. They're now binding on later appeals. The only downside from an advocacy perspective is in some cases the windows for submitting new evidence is smaller. It used to be you could basically submit right up to the point that they were going to make a decision, whereas now that's barred a little earlier. And that the path for the old way of doing appeals, which is what I call here the no new evidence, no new argument appeals, is narrower, meaning that if you, there used to be amongst veterans, it was believed that anytime you got anything from the VA, you just automatically appealed it right away. Well, now you can still do that, except that's going to put you on a lane really fast to being in that pile of cases that goes for miles and miles that nobody's looking at anytime soon. Whereas now, if you don't specify what kind of appeal you want, and you don't tell them what you want out of it, you're going to end up in that pile pretty quickly. So reflexively appealing a case is no longer a good idea. Next slide, please. So for now, the two systems are going to coexist. Like we said, that February 2019 day is key. A veteran in the legacy system can opt into the new system, but they can't go back. Any case filed after February 2019 is going to be in the new system. So like I said, it's been more than a year now, so there should be no more first-time appeals going into the legacy system. For the foreseeable future, we expect that the VA and veterans are going to confuse the two systems for a while. So a lot of what veterans know about this, they've heard from other veterans, and scuttlebutt is not necessarily good information, but that means you're probably going to encounter veterans for a long time that are going to know with absolute certainty what the legacy system was and not really know that there's a new system in place. So something to be aware of is that you need to know which system you're in order to be able to advocate and give the veteran their options. And that some of the impressions the veteran may have or things they may have heard from other veterans may no longer be true. Next slide. So when the VA implements a complicated new system with several thousand pages of law, they have to communicate to the veterans, and they did this to communicate it. I'm not asking you to read this. I'm just asking you to look at this and say, so the veterans are supposed to make a really important decision based on this slide. So there's still a lot of communication that needs to happen to explain what these are. Next slide, please. So like I said, the most important change in the new system is now you get to choose what type of appeal you're doing. So after that initial decision, you filed your application, you get a response. It used to be your option, if you didn't like the response, was to appeal, and that was the one answer. Now you have to choose from 3 different answers. Higher level review means that a more experienced adjudicator is going to look at the exact same case and make a decision. You're not allowed to submit any new evidence. Supplemental claims lane means you can add new evidence and have someone take a fresh look at it. And the board to veteran appeals means that the higher board is going to look at it. You're sending the case out of the regional office to make a decision. Next slide, please. So looking at this again, just summarizing what these 3 lanes are in ways that hopefully you can kind of remember which one they're fitting into. Higher level review is you telling them that they missed something or that they didn't give you a complete answer. They didn't tell you what evidence they considered. They didn't tell you what steps you had to take, what medical evidence was missing. The supplemental claim lane is for, here's the evidence you said you needed. You rejected the claim, said I didn't have certain evidence. I'm giving it to you now. Here's some more evidence that may change your mind. Here's something material to the case that you should look at that you didn't see last time. And the Board of Veteran Appeals says, I want to speak to your manager. I'm getting out of the regional office. I'm going over your head. I'm taking it to the professional bureaucrats. Next slide, please. So the higher level review is supposed to take an average 125 days. When I made these slides, getting close to a year ago, that was the case. It has not been my experience, but my anecdotes may not be what everybody's experiencing, but that is supposed to be how fast turnaround time is, which is, again, significantly faster than you got before. You can't add new evidence, but you can make a new argument. So if you're taking on the role as an advocate for the first time, the veteran didn't have representation when they initially applied. If you take all the evidence they had and make a legal argument out of it, that is not new evidence. So you can do that on a higher level review. You can also use it the same way you would in a civil case as a form of motions and practice and discovery, where they are required to give you what they considered, how probative value they gave the evidence. And so now you can get a lot more information about your claim before you get into that line that's going to take, a few years. Whereas before you filed that appeal and you said, well, wait, did you even look at this stuff? And you file the appeal and you wait, and then they come back and it turns out they didn't. Next slide, please. So the caveat to the supplemental claim is you have to submit new evidence. So that means it has to be new and relevant evidence, and you have to tell them what the new and relevant evidence is. So you can't just say, well, I've gone to an extra doctor's appointment since then. Well, if the doctor didn't tell you anything different than they did last time, that's not new and material. New and material means something that they didn't have the last time they considered the case. It's supposed to have a turnaround time of 125 days as well. We'll see. Next slide, please. Now, the third choice, and we're branching here, so the third choice was appeal to the board. That requires you to make another one of three choices that look a lot like the last ones, which is you're appealing to the Board of Veteran Appeals. Now you've got to tell them I either want a direct review, which is, again, just look at the same case as it was before, but now the Board of Veterans Appeals is doing it instead of a higher level review by someone at the regional office. I want to submit new evidence, like the middle supplemental claims lane, or I want a hearing in front of an administrative judge. So I'm not going to do it all by paperwork. I want to make an appearance. Next slide, please. So there's supposed to be a 365-day wait for claims that don't have any new evidence. If you're submitting evidence or requesting a hearing, there's no timeline they're giving. So I assume you're going to be in the same line as the legacy cases. Minor changes they made to evidence submission is that new evidence can only be added 90 days after the appeal. Where it used to be you could do it right up to the end. And same thing with a hearing, you can only submit new evidence 90 days before the hearing, where before it used to be you could submit new evidence right up to the end. Well, not right up to the end, but closer to. Next slide, please. So this is the big difference of what they did before. There used to be statements of the case that just kind of generically said, we found this condition is not service connected. Okay, that's great. You looked at 600 pages of paperwork and that's what you found. Now they're not supposed to be able to do that anymore. Now the VA, when they give a statement of the case, they're supposed to explain what they considered, summarize the evidence that they used. This is different before. They only had to list it. Now they're supposed to summarize it and tell you what they thought was in there. Identify favorable findings for the claimant. Again, they didn't have to do this before. Now they have to say, well, we found that the evidence says that the veteran has a current disability. We found that the evidence said that the veteran, has wartime military experience. Any of those findings they have to state now that are favorable towards them advancing the claim checks one of those boxes you have to prove. And more importantly, those used to not be binding on future findings, but now they are. So it means if the regional office says that you have a you have a disability, but it's not service connected, that finding of a disability is now binding for the rest of your claim. So there's a lot more that can be done at the regional office now, whereas before, if the regional office didn't give you the answer you wanted, you really didn't have a choice. You had to go higher. Now you have a way to get answers that are helpful to you later because you don't need to prove them again. You have to identify the elements you didn't meet. So again, this is just giving you a roadmap to the case saying, this is what we wanted to see and didn't see. Well, now you've got a very clear mission of what you got to produce for them in order for them to approve the claim. So what this means, all these changes mean is there's a lot more room for advocacy now. Because they're giving you more information, there's a lot more you can get out of the regional office, out of these reviews. Next slide, please. So, and I think this is particularly true for how you can use a higher level of review. Well, what difference does it make if somebody looks at the claim that is higher than the person that made the initial answer? Now, because they're supposed to give you all this information, if they don't, that's who you complain to. You can get a turnaround time that's not going to be years to say, you didn't explain to me what the veteran was missing. You listed this piece of evidence that I think is important to the claim, but didn't say what you thought it meant. In other words, I don't think you read it. I think you saw it, listed it, and didn't actually look at it. And you can use the higher level review to do that now. So you use a higher level review to do that. You get you get your answer back. Now you've got someone that can look at it without having to submit new evidence or wait again. Because you can submit new evidence to keep the claim in the regional office, you can still do a higher level review after you submit the new evidence. So in theory, as long as you're producing some sort of new evidence every second appeal, you can keep the claim at the regional office continuously, which means that, again, in theory, you're getting a fast turnaround time on the answer, and you're also painting the VA into a corner where every time they're doing it, they have to give you more information about what they looked at, what they reviewed, what evidence they considered, what you were missing, so that if your claim goes to the Board of Veteran Affairs, you should have it fully developed by that point. You should be confident to say, I think I got everything that I'm going to get out of the regional office, and now I'm going to unfortunately have to wait a long period to get an answer. Next slide, please. So after the VA comes back with a denial, assuming that you did any one of these claims, you're going to be given the same choice to appeal again. So you can't do a higher level review after a higher level review. That's the only one. You can do a supplemental claim after a higher level review. You can do a higher level review after a supplemental claim. But you can't just stay in the higher level review period indefinitely. So what you're trying to use them for is you're trying to use the higher level review to narrow it down and figure out exactly what the claims review process they think is missing and what they think of the evidence you've given them. Supplemental claim, you still have medical evidence missing. So this is pretty common where your claim would be better if the doctor said different things. Trying to get the doctor to say different and better things is what the supplemental claim lane is for. It's saying, okay, we're going to get you better medical evidence. And in some cases, that's I'm waiting for something I sent to a hospital, or we're looking for records, we're trying to put together a medical case. But I think most frequently that's going to be used for here's new medical evidence you didn't have at the initial case. By the time you're getting to the Board of Veterans Appeals, again, I really think generally you're best off trying to avoid that as long as possible. But it means I've submitted all the evidence I'm going to get and I think I need, and I just think that at this point the regional office is making mistakes, and I want to go to someone higher that's going to more develop this claim, that's going to have a more sophisticated understanding of the case we're talking about. Next slide, please. So the Board of Veterans Appeals is going to be more resembles what the normal advocacy process you're looking. Their written opinions include statements of law and the kind of responses you're more accustomed to. But because there's no targeted time for turnaround on those, again, we're just expecting it to take the same, years for answers before. That's why it's kind of, in my opinion, got such an important act you can do as an advocate for a veteran is to try to keep them out of that. if you can get your client an answer in a year by constantly churning the case at the regional office level, you're doing them a favor versus getting them an answer in 4 years, even if the answer is the same. Next slide, please. So the practical reality for now is that the dual system is going to be confusing. Veterans are going to confuse it. VA is going to confuse it. VSOs are going to confuse it. And that's why at this point, when you've done the CLE, you have to assume that you're smart and you know what you're talking about when it comes to the new system, because a lot of people are still getting used to it and all the information that gets out there isn't necessarily good. I think, again, the new system is much better for lawyers. There's a lot longer explanation advocacy you got to give for that if I had time, but we're pressed for time here. But to only impart on you the idea that, before, my feeling was until you were at a certain level, you were doing a kind of administrative law, where now there's a lot more chances to make arguments and to put a case together for a veteran. Next slide, please. Oh, we're skipping comics, but I think we made it in with 3 minutes early, but y'all are going to get the slides at the end anyway. So Diane is going to finish up real quick on what happens after the VA. You've exhausted all your claims, you've made all your appeals. The VA's final answer is no, and now it's time for federal court.
That's right. If you are going to appeal a BVA decision, you can appeal it to the U.S. Court of Appeals for Veterans Claims, or CAVC. I touched on this earlier. If you choose to appeal to the CAVC, you have to get a separate, you have to file a separate application for admission to the CAVC. They have exclusive jurisdiction of BVA appeals. You have 120 days from the date of the BVA decision to file that appeal. And this is a federal court. They're not a part of the VA. After the CAVC, if you wish to appeal that decision, you go to the U.S. Court of Appeals for the Federal Circuit, and then from there you can go to the Supreme Court. And that wraps up our presentation. I see some questions. Let me see. If we have a case where the regional office is misapplying the law, should that go to the Board of Veterans Appeals? You can. There's also something called a clear and unmistakable error. If the VA is making a clear and unmistakable error, you can file that particular type of appeal. And in that case, it seems like that if they're misapplying the law, that would be a clear and unmistakable error. I saw 10 minutes late. As we mentioned before, oh, go ahead, sorry.
Just say on that last question, that would be the appropriate time, assuming you've gotten everything else out of the regional office you plan on getting. You told them you think the law is different, they disagreed with you, and there's nothing else you're going to get from them, then it's time to move up to the next level if you don't agree with their application.
Right.
Other medical evidence or anything like that, submit, I would even then still keep it in there. You can always include that in your argument saying, I think the law says this and you should apply it differently. But you really want the only thing to be going to the Board of Veteran Appeals, that one narrow question of law, and not anything else that you're going to have to do to develop the case.
And this last question here, we're going to be sending an email out with the CLE course information that you can use to submit to both the Office of General Counsel and the State Bar. We will also be including the slides on that email, as well as a link to this presentation because it's being recorded and you guys can access it later. And with that, we have a break scheduled before our next presenter, William Gwynn. Justin, would you like to say something?
Yeah, I was going to try to answer Linda's question about Agent Orange. I don't know if she got the answer she was looking for. And Agent Orange is pretty specific about when you served, where you served, and then the health conditions related to that were actually statutorily tied to Agent Orange. So there's quite a few specifics that we'd have to know.
Right. All right, then. let's do our break and then we'll come back. 10 minutes, right, guys?
Yep.
All right.
All right, let's get started in a couple more minutes. All right, as soon as William's ready, we can go ahead and get started.
Okay, I'm ready to go. All right, hi everyone. My name is William. I'm a paralegal at Lone Star Legal Aid with the Military and Veterans Unit. I've been there for a little over a year. Just a little bit about me. I served in the Marines for almost 6 years. I went to Iraq a few times. I worked for the VA for almost a decade. I've worked in Washington, D.C. at the Appeals Management Center where they process the appeals. I've also worked with veteran nonprofits and also a private attorney down in Florida who did nothing but work on veterans appeals up at the board and at the court and just working through all that. So that's just kind of a little bit about me and my background. And so today we're going to go ahead and cover discharge upgrades, VA character of discharge reviews, and some non-service connected pension benefits. Next slide, please. Robert, next slide, please. Thank you. These are what we'll be covering. As I stated, VA character of discharge review, discharge upgrades, non-service connected pension, aid and attendance, housebound, and if you have any questions, I can answer those as well. Next slide, please. All right, so this is the first steps for a character of discharge review. A character of discharge review is something strictly that's done with the Department of Veterans Affairs. So these are the steps that a veteran would have to go through in order to get one done if they did not receive an honorable discharge. I'll touch on each one of these steps in the next few slides, but eventually you're just gonna ask for a review by applying for a benefit. So you can go to the VA hospital, they can apply to try to get health care through the VA. That will trigger something at the VA because they're gonna notice their discharge. That's not a decision for the VA healthcare staff to make on whether or not they're eligible for healthcare. That is strictly done at the Veterans Benefits Administration, which is a separate administration from the Veterans Healthcare Administration. So they would essentially send a paperwork over to the VA regional office that would initiate that process, and they would notify the veteran of evidence they needed, give them the time frame they would need to submit that, and then they would proceed from there. Next slide, please. All right, step one, ask for the review. Other than going to the VA hospital for healthcare, they can apply for service-connected disability. That's what was covered in the prior webinar. Also, they can apply for non-service connected pension, which is what I'll be going through a little later, or home loan eligibility. Please note that just because they apply for a home loan does not mean they actually have to buy a home. They're just trying to get their home loan eligibility certificate, which does require a honorable discharge or to have their service rendered by the VA to be honorable for VA purposes. Next slide, please. All right, step one, continued. You can apply for service-connected disability with that VA form 21-526EZ. That's what was stated previously. You can just apply that. They'll pull up the service, note that it's not honorable, and then they'll start that process. And they'll have to make that decision first before proceeding on and making the decision on the disability claim. For elderly or disabled veterans that the disability is not related to service and they have low income and they're wartime veterans, they can fill out the VA Form 21-527EZ to apply for the non-service connected pension benefit. Essentially, if they're not disabled but seeking access to VA healthcare or other benefits, they can fill out VA Form 26-1880. That's the form to help with like your the home loan eligibility certificate. It does not have to apply for a home loan though, but it does trigger the VA to do a character of discharge review first. Next slide, please. All right, explain the eligibility. Military records are only one side of the story. The veteran needs to tell their side of the story. The VA is going to see all the veterans' military records because by law, they have to request the veteran's personnel file to review all the personnel file and medical records. But that only is going to tell one side of the story and often only the worst side of that story. So when filing for a benefit, the veteran should attach a letter telling their side of the story up front about why they have the discharge they got, what happened, some circumstances surrounding that. And then they're still going to get an additional 60 days. They give them 60 days to acquire other additional evidence to submit. They can also request a hearing as well. Next slide, please. What's the veteran's story? So did they have a mental condition such as PTSD or TBI that was starting to affect them while in service? A lot of times veterans don't know that what they're experiencing may be signs of PTSD or TBI. They might start to drink more and make bad decisions. A lot of times, I know back about 10 years ago, the military was not very receptive to allowing guys and girls to go get mental health treatment because it was frowned upon. So you kind of want to look at other things. Did they get in some trouble? Obviously they did. What kind of trouble was it? Did they get in trouble for maybe smoking marijuana? Okay, well, why? Well, I couldn't sleep at night. It helped me to sleep. Okay, well, having sleep problems can be one of the first signs of PTSD. So that's something you want to look for. Were they experiencing personal problems at the time, such as family problems or harassment in service, sexual harassment, a divorce, wife cheated on them, a child died, something like that. Were their conditions of their service stressful in the period leading up to the discharge? Meaning maybe they went to Afghanistan or Iraq, or they, experienced, something close to home, maybe a natural disaster like Harvey, and they were, mobilized for that. Did they have accommodations for good service before the problem started? How long was the good service before they were having troubles? Most branches, I believe, I know the Marines, it's 3 years of good service and you get a good conduct medal. So if they have something like that, most enlistments are 4 years. If you notice that they have a good conduct medal, that means they had at least 3 years of honorable service where they didn't get in any trouble, or at least didn't get caught and got in any trouble. So always kind of look for that, because that's going to kind of help you say, look, he was going to do his 4 years. He had 3 years of honorable service. He deployed to Afghanistan, came back, wasn't able to get any mental health treatment, and he smoked marijuana once and you kicked him out. And kind of make that, part of kind of the argument of where you want to go and try to tell their story of why they did what they did. Next slide, please. All right, speak the VA's language. This is unfortunate that you kind of have to speak their language to get them to understand what you're trying to say, but it is very helpful to do so. It just makes it a lot easier, hopefully, on them to see what you're trying to say. So in a lot of this language, I'm pulling from the CFR, because that's the language they're using for what it takes to possibly, get that decision favorable for them. So they want to see my misconduct was not willful. So this again comes back to the mental health crisis at the time. Were they experiencing a mental health problem? Therefore, what they did, they weren't willfully making that decision because they weren't in their right frame of mind. The next one, my misconduct was not persistent. Again, let's go back to like the veteran, and this is, these are a dime a dozen. Veteran smokes marijuana one time. That's the only thing he ever got in trouble for, and they kicked him out. Well, that wouldn't be persistent. It was a one-time isolated incident. They never did anything else. My misconduct was minor. Was the misconduct a small discipline problem or an off-duty behavior problem that did not interfere with their duties? Sometimes you'll see people who they might get in trouble and they might have, got in trouble for minor in possession of alcohol out in town. Well, why would we kick, like that was not a big deal, to get caught with alcohol, like a beer, like that happens all the time to people. Why did they just kick them out of the military? And then typically that would be like an off-duty behavior. A lot of the small discipline problems you'll see where people were getting kicked out, that at least I've noticed, were back in like Vietnam, in that era, and a lot of them unfortunately were happening to like African American soldiers, where they were getting kicked out for minor infractions that other soldiers would have maybe just gotten demoted or gotten restriction or something like that. So be aware of a lot of things like that where, oh, you bounced a check one time, we're going to kick you out, because I have seen that before. My service was otherwise honest, faithful, and meritorious. This is where the good conduct medal comes in. That's where any other decorations that they may want to, show that they received, like did they get any combat awards for valor while they were in Afghanistan or Vietnam or Iraq or wherever, cite to those. Did they get any, commendations? Did they get any letters of recommendation or, anything like that, letters of appreciation from anyone? Cite to all the good things to try to outweigh this, this incident of, bad, of a bad decision that was made by your client. Next slide, please. Request a hearing. File the benefit claim and send in a VA form 21-4138. That's just a statement in support of a claim, and just put on there, I request a hearing on the issue of my VA, of my character of discharge. You don't have to do a hearing. I always suggest to people that they do, only because it puts a face to paperwork. It allows them to go in and tell their story to that person who's going to make that final decision. And it also will allow for evidence to be submitted into the file in case there's anything that could be used on an appeal in the future, because those are all recorded. They will send a copy of the transcript to the veteran, or if you're the attorney of record, they will also send a copy of that transcript to you, so you have it on file as well. VA will schedule the review. I don't know how they're doing it now with all the COVID-19 stuff. From what I hear, I think a lot of it is like video teleconferencing for right now. Family and friends can quote unquote testify, so you can bring people in who maybe, like mom and dad knew that Billy smoked marijuana because he was having problems with, something from Afghanistan because he called and told them, and they saw the behavior change when he came home on, post-deployment leave, things like that, or an ex-wife or a current spouse. And again, it just puts a face with a file number. When I worked there, a lot of people just looked at it as a file number and not as a person. And so for me, I always just tell people, take your client in and do a hearing in person. Let them see that person, because a lot of times things will get missed when it's just written on a piece of paper. You can't see that person's, facial expressions to see, oh, wow, like, okay, this is really a big issue for them. This is, I really believe what they're saying. I really believe all this evidence that I have, plus their statement. Next slide, please. And then wait. Unfortunately, the VA can take a long time to make these decisions. However, if the VA decides in the veteran's favor for one benefit, it opens the door for the other benefits as well. Next slide. Other considerations: re-enlistment and multiple service periods. For most VA benefits, you only need what they call one good period of service. So typically, like, you enlist for 4 years, you would need that first 4-year period of service to be honorable, and you would be good for your GI Bill benefits, because you just need your first initial enlistment to be honorable for that. You could get disability benefits for any disabilities from that 4-year period. You would also be eligible for your VA home loan, your VA small business loan. However, if you have multiple periods of service, then those are going to have to be evaluated separately under this VA discharge review. They're going to have to say, okay, this period to this period is honorable, and this period to this period is dishonorable for VA purposes, because a lot of people, as you know, if you do 12 years, they don't give you 3 separate DD-214s. They give you one DD-214, and it just lists all 12 years. And then it should list in the comment section, at least I knew on mine, it listed, you know, re-enlistments this, you know, and it lists the date you re-enlisted on there. So if I have run across quite a few where they lumped in all of the enlistments in one and said they were all dishonorable for VA purposes, which they should not have done, and is definitely something I would appeal. Next slide, please. All right, the GI Bill. This does have special eligibility requirements. The DD-214 must say honorable. So even if the VA says, sure, we think that your service is honorable for VA purposes, that still won't get them the GI Bill. It will only help them with health care, and it will only help them with service-connected disability, non-service connected pension, you know, and those other ancillary benefits, but not the GI Bill. General discharge is not enough. A successful character of discharge determination, again, is not enough. They must receive an actual discharge upgrade by their service department in order to qualify for that GI Bill if their initial enlistment was not an actual honorable discharge. Next slide, please. All right, Reserve and National Guard discharges. These are a little bit different because the Reserve and National Guard do have Reserve and National Guard GI Bills. However, for Reserve and National Guard discharges, you have to have active federal service. The VA is generally only concerned with the periods of that active federal service. If the veteran was mobilized to federal service and received an honorable discharge, then the veteran should get VA benefits based on that period of service. If the veteran receives a discharge from the Reserves or National Guard later on that is less than honorable, that does not take away the eligibility they earned during their active federal service. So in short, what that means is most reservists will sign up, I believe it's like a 6-year reserve commitment. And let's say at year 2, they get mobilized and they're called to active duty for a year. They complete that honorable service. They get an honorable discharge for that year of federal service. They apply for benefits. They qualify for those benefits based on that discharge because they completed the period for which they were called to active duty honorably. But then let's say they decide not to show up for drills anymore, and then they receive an other than honorable discharge because they failed to show up for drills, and essentially what if they were on active duty, they would have been UA, so they just gave them an other than honorable discharge and kicked them out of the reserves. That would not change their eligibility for benefits based on that 1 year of active federal service. Next slide, please. All right, 2 years of service or less. Enlistment after September of 1981, typically you have to have 2 years of minimum service required in order to qualify for VA benefits. If they served a certain minimum amount of time, usually this is 2 years. Some veterans who were discharged early for misconduct served less than 2 years, and they might not get VA benefits even if they have a successful character of discharge decision. A lot of times that's where it comes into like the healthcare you have to have a certain amount of time in order to get the healthcare benefits, depending on when you enlisted, or for like the GI Bill. Sometimes you have to do a certain number of actual months to even qualify for a portion of the GI Bill benefits. Next slide, please. Benefits veterans can get anyway. Therapy. This is if this is still while they have that other than honorable discharge. They can still get therapy, medical care related to sexual assault, homeless shelter services, rental support assistance like HUD-VASH, unless they received an actual dishonorable discharge. However, that may be subject to change in the future. But an actual dishonorable discharge, that's something that happens at like a general court martial. Typically, they're serving time in like a military prison, and then they're being released. Next slide, please. All right, I didn't put the whole CFR reference in here, but 38 CFR 3.12 this discusses the VA's character of discharge process, what regulations they have to go by. It's well worth the read if you're going to help a veteran out with this or want to know more about what the VA has to consider when trying to make these decisions. Because let's say you have a guy who was UA or AWOL for 200 days. Well, if they were AWOL for more than 180 days, the VA cannot say that their service was honorable for VA purposes just based on 38 CFR 3.12. It's in one of the other sections a little further down. But they won't be able to say, sure, your service is honorable for VA purposes, because regulation would prohibit them from doing that. Next slide, please. Okay, a discharge or release because of one of the following offenses in this paragraph is to be considered issued under dishonorable conditions. I'm not going to read them to you. They're all right there. But if any of these pertain to your client, then they have to state that your client's service is dishonorable for VA purposes. Like, they can't go against that. That's just what the regulation states. Any question? Next slide, please. Are there any questions currently on the VA's discharge review process right now before I go on to the next section?
I think Alex has a question, Will.
Okay.
Alex, would you type your question in the Q&A box, please?
Okay, Alex's question is, does homosexual acts includes consensual acts? Okay.
So,
Before the repeal of Don't Ask, Don't Tell? Right, but okay, so, all right, so, okay, I see what you're saying. Right, but in the military, like, that's totally different. Like, they still had in 2004, they were still under Don't Ask, Don't Tell. However, if they were discharged under the old Don't Ask, Don't Tell prior to when President Obama had reversed it, they can apply for discharge upgrade. And I have, while working at Lone Star Legal Aid, we've had a client who was discharged for that, and it said on their DD 214, homosexual acts or homosexual behavior on there, like within, I think it was like 2008 or something. And they will review those and upgrade those discharges. I'm not saying it's 100% yes, because you have to also look at, was your client in any other trouble? Like, did they go UA, but then they also happen to, be homosexual as well? So there's nuance, but if it was just for that, they will review those and upgrade those discharges accordingly, to, how they're supposed to be now. And I don't know about anything, beyond that when it comes to if they had, disability claims denied before. I would assume most likely it's going to be one of those where it's from the date that, the law was repealed going forward, then they could reapply, once, that date, once it was repealed and they got their honorable discharge, then they could apply. But I don't know how it would go prior to that, if there's anything about that. Does that kind of answer that question?
I think so, Will. He said thank you. I just missed it out of the Q&A so we could.
Oh, okay. All right. So the next slide. So as you can see from my next slide, we have the VA character of discharge review versus like the discharge upgrade. So you can see, where the differences are and where the similarities and, are the same as well. They both can be appealed if they get negative outcomes. and they both will allow veterans to obtain benefits earned from service. However, there are a little bit of differences. You can see the time frame is a little different, and one, the VA makes the decision, and the other, the Veterans Service Department is making the decision. One changes the actual DD-214, and one does not. It's just internal within the VA system, changes their service to honorable for VA purposes, which shows the VA employees, okay, yes, they're allowed health care, they're allowed disability benefits, let them in, give them a VA ID card. Next slide, please. All right, discharge upgrade. These are things that I always look for when we get a client that wants to file for a discharge upgrade. I always ask, were there any sort of diagnosed mental health conditions while they were on active duty? Did they go seek mental health treatment and get a diagnosis of anything, depression, bipolar, PTSD? If they did, that's going to be very helpful. Those records will be noted in their service treatment records. Did they have a traumatic brain injury? As a lot of people know, especially made light with a lot of the NFL players, veterans are getting traumatic brain injuries, and that can alter their behavior, which, can cause them to, have behaviors which would possibly lead to, getting another than honorable discharge. Was there any sort of sexual assault or harassment during military service? The VA will refer to this as MST, or military sexual trauma. And then sexual orientation, including under the don't ask, don't tell policy. So these are all things that if you have, if your client has any of these sort of things going on, all branches of the military consider you to have a strong case for a discharge upgrade if you can show your discharge was connected to any of these categories. Next slide, please. All right, discharge upgrade. This is when you will need to provide evidence to the Discharge Review Board. Here's what you're going to need to send to them: the completed DD Form 293. I know it doesn't make sense, but a copy of the DD 214, pertinent medical records, police reports, veterans' personal statements. As you can see here, everything that they would need to make a decision that would help your client. Statements from mom and dad, statements from fellow soldiers or Marines that they served with, statements from a pastor about their behavior now, what they've been going through, how they've, changed their life. Different things like that all will help. Just please note that when they do a discharge upgrade, they are not upgrading the re-enlistment code. Well, the re-enlistment code is like what recruiters will look at if somebody were trying to want to re-enlist in the military. Some of them prohibit them from being able to re-enlist, such as the RE4 prohibits all re-enlistment in the military. Typically, this is what is given to people who aren't given an honorable discharge. Next slide, please. All right, so this is what you have to prove to the Discharge Review Board in order to have the best chance at getting a discharge upgrade. You have to show that the discharge was inequitable, meaning that the reason or characterization of that discharge is not consistent with the policies and traditions of the service, or that it was improper. The reason or characterization of the discharge is in error, like it's false or violates a regulation or a law. So you have to be able to show that. So a lot of people will say, well, I only got in trouble once, or I was young and I didn't know, that, this was wrong, or, I only smoked marijuana one time. Unfortunately, there's a lot of laws, and I know when I went in the military, I had to sign something saying that I understood that the military was, a drug-free, work environment, essentially. So you do have to show that it was inequitable or improper. There's different ways to do that depending on what your client was actually, discharged for and what the offenses were. Like if they got in trouble for, being late 15 minutes to formation, and it was the only time they got in trouble, and they got kicked out with another than honorable discharge, I would say that would be improper or inequitable, given that that's not consistent with any policies of any military branch that I know of to kick somebody out for being 15 minutes late one time. So that's what you have to prove to the board in order to get your client that upgrade in their discharge. Next slide, please. All right, time limits. So there are time limits per se. It's just time limits on where the actual packet and paperwork is going to be sent to. Not that you actually have a time limit to apply for one, and then if you don't, you're just stuck where you're at. So within 15 years of discharge, you're going to complete DD Form 293. After 15 years of discharge, you're going to fill out DD Form 149, which is just a change to your military records. So one of them will go actually like to the actual discharge review board. They review everything and they'll upgrade it. The other one goes to like, it's a more like civilian type of agency. They will review everything still with military people there, but it's just based on the military records, because the DOD and the military up in DC where they do most of these, they're not keeping all these records from like the 60s there. And then for the discharge review board, for the time frame, I've seen them done in as little as 6 to 8 weeks. However, it's more common to be, you know, the low end being 6 months to up to 2 years. And I don't know what their work is like now and what their backlog is now with the coronavirus. I can only imagine it's probably delaying it even more than it was before. Next slide, please. In cases where the veteran believes that PTSD or another psychological health issue led to the conduct resulting in the less than honorable discharge, it is important that the argument is supported with properly worded medical opinion. When appropriate, the medical opinion needs to explain the cause and effect of combat or stressful event like MST leading to stress severe enough to lead to the misconduct. So, for example, again, because the most common thing that you see nowadays with a lot of veterans getting kicked out with PTSD is that they did some sort of illegal drug and failed a urinalysis and got kicked out. So essentially, you would want, if that client has a psychiatrist or psychologist that they see, to have them write a medical opinion, you know, stating that, you know, while Mr. Smith was on active duty, he was deployed to Afghanistan, you know, based on, you know, the things that he's reported, and, you know, they list like, you know, some of the stressors that they have, you know, it's noted that he received an other than honorable discharge for his, you know, smoking marijuana one time. Mr. Smith reports that he couldn't sleep and he was doing it just to try to get some relief to what is now his diagnosed PTSD, you know, that he did not have diagnosed back then. You know, something along those lines, you know, maybe something a little better than what I just recited, but linking the cause and effect essentially. Next slide. Reviews and hearings. So this is on the DD Form 293. They can have the board review the application just on the evidence of record and whatever evidence they submit, or they can go to DC and, you know, stand before the board themselves. However, all those charges, you know, they have to pay for their own travel up there in order to do that. I'm not sure if they're still doing the traveling boards right now for some of the services where they'll go to, you know, a major city and they'll have, you know, hearings there. I'm not sure if they're doing that anymore right now with the coronavirus stuff. I know the VA has stopped a lot of those, but I'm not sure about if DOD's done that right now. Next slide. Okay, so here's the outcome. So if you're successful, then your client's going to get a new discharge certificate. So they're going to get a new DD-214, and they'll also receive, you know, a packet with the documentation of the decision. It'll list the evidence they considered, you know, the laws, the regulations, you know, any changes that were ordered, you know, because under President Obama as well, he ordered that new reviews be done on a lot of these veterans who were getting kicked out for, you know, drug failures, and then noting that there was a systemic failure in the military to provide adequate mental health treatment for veterans suffering from PTSD due to combat or sexual assault or sexual harassment and whatnot. And then if it's unsuccessful, they're still going to get documentation of the decision review board's decision with all the same stuff. It's just going to obviously be why they had to not give a positive decision. They'll give the specific reasons, and then they'll give them a description of further appeal process if they wish to appeal that decision further. Next slide. These are just important addresses. This is the Army and Air Force where you would send that discharge review packet to in order to have, if your client was in the Army or Air Force. So, of course, one's here in Texas and the Army's up in Virginia. Next slide. All right, and then you have the Navy and Marines are up in DC, and then the Coast Guard as well. So again, and these will all be on the form that you fill out because they're going to give you the address on where you need to send everything on the forms, depending on where you're going to go with that. The next slide, any questions on this section before we move on to the non-service connected pension benefits? Okay, I don't think there are any questions, so next slide, please. All right, VA non-service connected pension. All right, so VA non-service connected pension is for over 65 in a nursing home, has a non-service connected disability that's permanent and totally disabling in nature. So essentially they're disabled. They are financially distressed. They meet the VA's income and asset guidelines, which we'll discuss further, and they have to have wartime service, meaning they must have served during a period of wartime that resulted in a discharge under other than dishonorable conditions and must have served at least 90 days of active duty and at least 1 day of service must have been during a period of war. So it doesn't mean they actually had to go to Vietnam. They just had to serve that 90 days of 1 day during being when the Vietnam War was active. Next slide, please. All right, here's your VA pension program options. You have protected pension programs. You have the improved pension programs. That's going to include, and we'll go through the next steps with the basic eligibility, aid and attendance, and so forth, and some other slides. And then the VA pension management centers, I'll go over and to let you know where those are located as well. Next slide, please. All right, so the VA pension programs, you have Section 306 pension, which they consider, which in the VA is called the old law pension. And then you have the improved pension, which is just how it sounds, improved. Next slide. So protected pension or old law pension, they can switch to the improved pension at any time. Benefits rates are protected. They never increase. Improved pension will pay a higher monthly benefit though. However, under protected pension, there's no additional benefits if eligible for aid and attendance or housebound. Just know that there are no more veterans being added to this old law pension or Section 306 pension. All new applicants are all going to be under the improved pension. So, so anybody new is going to all fall under that old pension plan or the new pension plan. But if you have any old clients who are having any issues, you might want to look at, looking at getting them into that improved pension because a lot of your older clients might need aid and attendance or housebound benefit that they're not getting under that old law pension. Next slide, please. All right, so improved pension provides financial benefits to eligible veterans, of course, non-service connected disability and 65 years or older. And then a dependent income is considered. So if they have a spouse or anyone else in their household that's living with them, and the claimants must provide the VA with their social security numbers when applying for pension. And that's just because they are going to take into account any social security disability income when making their decision. Also, they're going to run that social security number. They do have a matching system with social security that will run it for taxes to see, are they working? Are they making more money and not reporting it? And so in order to apply for these benefits, you're going to fill out that VA form 21P-527EZ, and this will help with improved pension. Veterans can be eligible for that aid and attendance and household benefits if they meet the statutory requirements for that additional monetary assistance for their non-service connected disabilities. Next slide, please. All right, so the basic eligibility criteria for improved pension, again, over 65 in a nursing home or has a non-service connected disability or disabilities that are permanent and totally disabling in nature. So if they're over 65, they don't have to prove disability. If they're in a nursing home, they don't have to prove disability. If they're under 65, then they have to prove that they have a non-service connected disability that's permanent and total in nature. The other two, 65 and in a nursing home, just have to show they have a non-service connected disability. All right, they have to meet the VA income guidelines, which is typically what the current poverty threshold would be. And of course, they have different rates for the more people you have in your household. Obviously, the more income you can, be allowed to have and still be eligible for this program. And then obviously have the wartime service and demonstrate, obviously the financial need is the big portion of it outside of the wartime service. Next slide. Okay, so aid and attendance. So this is an additional monetary amount paid on top of the typical just regular monthly pension amount they would get based on their income, or I should say lack thereof of income. And they must meet one of the following. They must require the aid and attendance of another person to perform activities of daily living, blind or nearly so blind as to have corrected visual acuity of 5/200 or less in both eyes, be in a nursing home due to mental or physical incapacity, or be quote unquote bedridden, or that which is a medical condition in which the veteran must remain in bed. So that's what they have to have in order to qualify to get the additional monetary benefit for aid and attendance. Next slide, please. All right, housebound. So this is a benefit paid in addition, again, to the monthly pension. This increased monthly pension amount may be added to their monthly pension amount when they are substantially confined to their immediate premises because of a permanent disability. So it's either they have a single disability that's evaluated at 100% disabling and confined to the immediate premises, or you can have a single disability as 100% disabling and another disability or disabilities that are evaluated at 60% or more disabling combined in order to get the housebound. So you have what's essentially considered like housebound in fact, meaning you're 100% and you're confined to your home, or you're statutorily housebound, meaning you have 100% and additional disabilities up to 60%. Therefore, you qualify for the housebound disability either way. Next slide, please. All right, income and net worth. So the IVAP, or the income for VA purposes, must be below the improved pension income limits or the maximum annual pension rate set by Congress. That changes typically every year because typically most years veterans are getting a cost of living adjustment increase in their pensions and in their VA service-connected disability benefits, which is typically commensurate with whatever Social Security is getting that year. So the rates will change typically every year. So you just need to be cognizant of that and look at the new pension rates, come January 1 of every year. All sources of household income are included except deductions such as unreimbursed medical expenses, SSI, and certain educational expenses. If income is less than the maximum annual pension rate, then the veteran meets the income criteria for that non-service connected pension. Next slide, please. The veteran's resources must be determined insufficient to meet their needs without VA support. That net worth is going to be calculated by totaling the market value of all real and personal property owned by the veteran minus any outstanding mortgages. And of course, the net worth that consists of stocks, bonds, investments, property, et cetera, things like that they'll take into account. Because if you have all that, what they do expect is that the veteran to use all that up first to support themselves, and then if they still can't, after all that is exhausted, then come back in and they might qualify for more benefits. Next slide. All right, what income counts? So income received by the veteran and dependents from sources such as earnings, disability payments, retirement payments, interest and dividends, farming, business enterprises, life insurance policy proceeds, and inherited shares of marketable stocks. All right, next slide, please. Excluded income, welfare, fire insurance proceeds, profit from selling real or personal property, and those unreimbursed medical expenses. Right, next slide. And the benefit amount. So the benefit amount, the way that they conduct the benefit amount is they take that household income. If it's a single veteran, then they use the single veteran maximum annual pension rate, and they take that rate and they subtract however much money that the veteran is reporting for income from that maximum annual rate. Whatever the difference is, they divide that by 12, and that will be your client's monthly pension rate. So just for the sake of this presentation, let's say the maximum rate is $12,000 a year for a single veteran. Your client makes $8,000 a year. So then they would take 4,000 divided by 12 and get whatever that is, $330 or something like that a month in pension. Now, if their income goes up because they get, more money, or retirement kicks in, they need to immediately let the VA know. That way the VA can adjust their pension rate. That way they don't get an overpayment, which will then cause a lot more problems in the long run. Or if they lose income, they need to immediately let the VA know. That way the VA can adjust in the other direction and give them more money for their pension because they warrant that money. All right, next slide, please. Now, this was an old rate table as of 2018. If you just Google the VA pension rates 2020, the new one will pop up, but it doesn't change very much. Doesn't change by, thousands of dollars typically. But here you get a general idea of, what they're allowed, what veterans are allowed to make for annual income and still be considered income eligible for that non-service connected pension. The next slide. Here are your pension management centers. There's only 3, Philadelphia, Milwaukee, and St. Paul. And each pension management center receives claims from offices within its jurisdiction. So if you have a client here in Houston and they apply for pension, then their claim is going to go all the way to St. Paul to be worked. And the good thing is it's all done electronically now through e-file systems. So it's not like when I first started working at the VA, they had to literally mail these big old red rope folders back and forth between offices. So it does make it a lot easier and quicker, but they are centralized in those 3 locations. Next slide. Again, I cannot emphasize this enough. Please make sure that they are reporting their changes in marital status, dependence, and income, because all of that allows them to either make more money and still be qualified for the non-service connected pension benefit, or in the other direction, it could make them not be qualified anymore, and then they have that overpayment that they have to try to pay back or get a waiver for, and that just makes life so much harder for them. Next slide. These are just some additional questions that we kind of pose to a lot of our clients here at Lone Star Legal Aid, just to try to help them with other benefits they might not know about. So like here in the state of Texas, like if you're 100% disabled, you don't have to pay property tax at all on your home. But also the state of Texas is one of the few that also has a prorated amount in 10% increments. So if you're 30%, then they will, knock off a certain amount based on, what percentage you are, up to 100% where you don't have to pay any at all. And then also they have federal student loan forgiveness for veterans who are rated permanent and totally at 100%, or they've been rated as unemployable by the VA. They can get any federal student loans forgiven. And I've done that personally, and I think I got like $36,000 as federal student loans forgiven. Unfortunately, back when I did it, we still had to claim it as income. So that didn't help me in tax season, but I hear now you don't have to claim it as income. So if they are 100% and it's permanent in total, they need to go ahead and apply for that if they have any federal student loans. And then also here in Texas, they have a great rate on if you're, I believe it's 50% or more, you can get the disabled vet tags here in the state of Texas. I want to say, I think this year, I think it's $11 for the, or I'm sorry, $4 for the tag, I think, and then $7 for like the state inspection portion they charge you now or something like that. So these are just some questions we throw out there to try to help, maybe you with your clients with other benefits they might not know about. There's links included to get them to, where they need to go to fill out the paperwork to submit for each of these different benefits that they may be entitled to. And the last slide, are there any other questions?
There was a question earlier from Kathy asking about the pension, if it's disability or 65 or older. It is. It's either permanent disabled or 65 or older.
Right, correct. So yeah, if you're 65, they're not looking at you to submit medical evidence to show that you're disabled. They're taking it, most people at 65 are receiving Social Security. They're assuming you've probably got some non-service connected disabilities that, would make you eligible either way. And then I saw John's over here says, I assume wartime includes undeclared wars. No, it does not. It only includes declared wars. The VA has a list of all the wars and the dates that they go by. Currently, the only war that does not have an end date is actually the Persian Gulf War, which started back in 1991. So technically that war has been going on for 29 years. So any veteran who served once that war was declared, and pardon me for not knowing the date that that war started, in going forward until one president decides to officially end it, then all these veterans now all have wartime service that could potentially file for non-service connected pension if they ever needed it.
August 2nd, 1990. So this
There you
year,
go. So
30 years.
Coming
This
up on
August.
30 years. So for the past 30 years, you have a bunch of wartime vets that will be able to file for this non-service connected pension benefit because no president has technically ended that war yet.
Any other questions? All right, I think our next presenter is Stacy.
Yes, I think I'm next. So my name is Stacy Bigger. I'm an attorney here in Houston. I've been practicing now for a very long time. My specialty is criminal defense, particularly in mental health. I got involved in the Veterans Treatment Court, basically because I was finding that I was having a lot of difficulties breaking through the VA, and that's how I kind of got started with all this. Go to the next screen, please. What we were finding in Harris County was that we had a very large problem having veterans in the jail. We had, at the time, not so much now because they're doing bond release and different things like that, but at the time, we were finding that we had about 800 veterans detained in the jail at any given time. This number was increasing. We were finding that there was a larger rate of mental illness in our veteran population than there was in our non-veteran population. And looking at this and figuring out how we could address this, one of the things that was decided upon was to go to our legislature and ask for a veterans court to be created in the state of Texas. Next screen, please. In 2009, Harris County Judge Mark Carter went to the legislature and asked for the creation of the first Veterans Treatment Court in the state of Texas. This was kind of sort of started by the gentleman you see in the picture, Marty Gonzalez. Marty Gonzalez had been in Judge Carter's court as a defendant, as a former Army captain. Judge Carter began to speak with Marty, found out Marty's story, not just what Marty's charge was. And Marty had been charged with a felony DWI. He had combined pain medications and alcohol and had crashed into someone's home. Fortunately, nobody was hurt or anything like that. He learned that Marty had multiple tours. He had 3 Purple Hearts and 2 Bronze Stars, and was not facing the traumas that he had experienced, nor was he getting the treatment that was needed. He placed Marty on a pretrial intervention, which is a way to keep Marty's record clean, and started working with getting him connected and treated at the VA. This was pretty much the case that started why are we letting these veterans be in our system, and why are we not doing something to get them back on the right track and get them out of the criminal justice system. Next screen, please. So with this, one of the goals is to create a treatment team for both felony and misdemeanor offenses that would deal with mental health and addiction, to divert them directly to the VA. There was benefits to our county to be able to explain that these veterans can get treatment through the VA. It doesn't cost the county any additional, where if they were placed on probation or use probation services, those were things that would actually cost the county money. And so we're actually benefiting the county by that, and not also in turn benefiting our veterans. In diverting them quickly, we would reduce jail time. That would also be costs that benefited the county. We've been proven to reduce recidivism. It'll help mental health recovery. You get veterans into the same community. And we found that veterans was much more successful in the reentry into our community. Next slide. So Harris County now has 2 veteran courts. It's no longer Judge Carter who runs the felony treatment court. It is now Judge Powell. And in 2014, Judge Mike Fields created the misdemeanor veterans court, but that is no longer Judge Fields' court. It is now Judge Erica Hughes' court. And both Judge Hughes and Judge Powell have done a great job transitioning and continuing the success of these courts. Next. Both in the felony and in the misdemeanor courts, they're collaborative courts. And so everybody works as a team, and obviously the judge has the final say. But in this team, you find the judge, the prosecutor, the defense attorneys, which we have 2 of, case managers, probation, mentors. We have the Veterans Justice Outreach Coordinator. We have forensic psychiatrists that come from the VA, and then, like I said, Harris County Probation. Next screen, please. The eligibility in order to qualify for one of these courts is that you must have an honorable or general discharge. You have to obviously have a pending case in misdemeanor or felony court. You have to be a legal resident or a citizen of the United States. You have to be a resident of Harris County. We have taken some surrounding counties, but sometimes we'll work with, now there's other veterans courts in almost every county that surrounds Harris County. And so sometimes we'll work with those courts in conjunction. You have to have a mental health, a traumatic brain injury. It could be military sexual trauma, or a substance use diagnosis that would be related to the offense to be eligible for VA services. And usually you're a first offender, or you've served in combat or hazardous duty. I will say that last one, if you have a client or somebody that you think just because they're not a first offender or they didn't serve in combat or hazardous duty, go ahead and apply. I think that we've now been around for 11 years, and we've found a lot of success with people we didn't necessarily think we could have success with. And so they're a little bit more open into looking at that criteria and eligibility. Also, if you do have a client that has military sexual trauma, definitely apply, because honestly, there is no treatment that you could find on a probation side status. That treatment you could only be obtained by the VA in order to successfully start to work on those traumas. Next screen. However, we don't take all cases. So anything that is an aggravated assault case, okay, let me back up. We don't take aggravated offenses. Aggravated offenses would include murder, aggravated robbery, aggravated kidnapping, those sorts of things. We do, however, take aggravated assault cases. It's very controversial. It's something that not all veterans courts in the United States do. We do not, however, take delivery of controlled substances, nor do we take sexual offenses. But with the aggravated assault cases, we have, believe it or not, we have actually found more success with those than we have with possession of controlled substance cases where it's personal use. Also, if they have a previous offense for sexual assault, murder, aggravated kidnapping, anything like that, then they're excluded. We have found that if they do have a serious and persistent mental illness, such as schizophrenia, things like that, it's very difficult to participate in our program. Fortunately, because our program exists and has been existed for a while, it is opened up the VA to be participating in other mental health courts, other mental health dockets that we have, and so forth. And so honestly, the Veterans Court has really helped bridge for many other defendants or criminal justice veterans that would be involved but may not be eligible for this court, but could still get services and be successful in another sort of treatment court. Also, we don't do repeats. So if you've been terminated or graduated from the Veterans Court, I think we say we don't. However, honestly, we have probably accepted people from on a handful of occasions from other jurisdictions that may have participated in a Veterans Court, and I know that we did repeat one. Next slide. So basically, to get into the Veterans Court, it's a referral process, and it's a voluntary program. You have to want to participate in the Veterans Court in order to in order for you to be accepted in there. And so there's a referral process. They then have a formal assessment, and then eligibility and suitability is determined. Once that takes place, there's an orientation, and then they enter into the program. Next slide. The referral process is usually initiated by a defense attorney. It could be initiated by a judge because we've been around for a while, and now veterans courts are popular, not just in Texas, but all around the country. Quite often you'll find that actually the veteran will be the person who is the one that contacts us regarding our program. We've also built upon other resources for veterans in the jail. And so there is actually a Stars and Stripes tank that is specifically for veterans. And we actually get a lot of information through the Veterans Justice Outreach, who go into the jails also and will educate people that the program exists and that the services do exist. So we do get referrals from all those sources. Once there is a referral, then it has to be approved by the judge of that court and the chief prosecutor of that court. Once those things have taken place, then the defense attorney or the attorney for the client needs to contact either Ariel Sanchez or Michelle Barnett. Ariel is the court coordinator, and Michelle is the probation officer assigned to our court. Through the two of them, they then get the file to the Veterans Court prosecutor to begin the eligibility criteria. Next slide, please. So the Veterans Court coordinator will send out a request of information to the Veteran Justice Outreach coordinator to make sure that that person is eligible for our program. So as I said before, you have to have an honorable or a general discharge. You also have to be able to receive VA benefits. Once that takes place, then there is an interview that is done, an evaluation with our forensic psychiatrist that's assigned to our court. She does an evaluation to determine whether or not there is a nexus between the offense and the diagnosis. So they want to make sure that the actions of the client are one that can be connected to their service diagnosis. Once that evaluation's been done and that evaluation has been approved for acceptance, it goes to the team. The DA is the initial person it'll go to. The DA has already said that it would be somebody they would work with if that evaluation takes place. So then they make an offer to the defense attorney for either probation, deferred adjudication, or pretrial intervention. Then once that decision has taken place, and I would take one step back and just say, if you are representing a client that is criminal justice involved, then I would make sure that when you're at that plea point, that you are looking at whether or not that can be something that is taken off their record. There are specifics to the expunction laws for veterans. And so there's certain offenses that and certain things that may not be eligible for expunction if you were not in the Veterans Treatment Court. But if you successfully graduate from the Veterans Treatment Court, the goal is to get this off their record, get them a clean record, and get them back on track where they need to be. And so make sure that whatever you're pleading them to, even though they're in the Veterans Court, that you're going to ultimately be able to clear that record down the road. So once that person has been approved and once there has been a decision as to what sort of either probation or pretrial intervention they may be receiving, they will attend an orientation. That orientation will tell them what's expected of them. To be really honest with you, to do Veterans Court is much more complicated and requires more work than if you were to do a regular probation. However, the benefits of being in the Veterans Court are great. And the reason being is because you're getting many of the clients that I get at the very beginning will tell me, hey, Miss Stacey, I stick to myself. I'm not a problem. I'll do whatever I'm told to do. And that's exactly the opposite of what we want them to be. We want them to be involved. We want them to be connected. We want them to be participating. We want them to reintegrate into a life of support and one in which they're not just thinking that they have to do this alone and by themselves. Like I said, this is a voluntary program, and we don't want anybody to participate unless they understand exactly what's going to be expected of them and the sort of things that we're going to be asking them to do. Once they understand all that, then they're scheduled to plead before the court. Next slide, please. And then the client begins the program. The program is made up of 4 phases. And during these 4 phases, the first phase is probably the most intensive. You basically kind of go from the VA services, and you're going to have people address all sorts of different things in their life that have just culminated to get them to the stage they are where they're with us. And so those can be a lot of different factors. That can be PTSD, that could be that they're going through a divorce or they're having issues with child custody. It could be that they're unemployed or they're homeless. Housing is an issue. Oftentimes, the reason that we do take assaultive cases and things like that is because oftentimes it's within the home is where it's actually seeing things, that there's fights and so forth taking place because they see the problems that their loved one is going through. They don't necessarily want to leave them, but they cannot continue to live in that environment anymore. And then oftentimes too, alcohol and substance abuse is a very large factor. Unfortunately, alcohol for many people in the service is one, a way of socializing and having camaraderie, and 2, it is their escapism. It's okay because it's just alcohol. However, that alcohol abuse continues to create other problems. And then you also have a multitude of mental health issues, depression, PTSD, military sexual trauma, traumatic brain injuries, all sorts of different things that need to be addressed on an individual basis. The next slide. So once somebody is admitted to the court, regardless of if they're on probation or pretrial intervention, like I said earlier, it's a 4-phase program. This program, like I said, starts very intensive with the VA services, and we're going to address all those issues and problems that they have. And then as they go, they'll start maybe attending outpatient care. Maybe it would start with inpatient care and then outpatient care. You're starting to work on getting them, if they don't have housing, we do utilize things like head vash and things like that for the homeless programs, trying to just kind of get them back into where they need to be on their feet. For those sorts of things, when you go from phase 1 to phase 2, the phase 1, you're really just focusing on them. Phase 2, you're trying to see how you can continue to keep this take place. When you're in the first 2 phases of the program, it requires more intensive observation by the team and by the court. You're going to come to court at least twice a month. You're going to be staffed every week. You will be attending your programs more intensively. You will be having more interaction with the VJO, with the psychologist, all those sorts of things. Then in phases 3 and 4, you're looking to try to get them where they need to be. They won't come to court as often. They'll start to just maybe attend groups, or right now because of COVID, we're doing teletherapy. There's a lot of changes in COVID, and we've tried our best to keep as much hands-on as we can, since COVID is such an isolating event, even without any sort of mental health issues that might cause you to isolate in the first place. And then phase 4, we're trying to get them set up, and so forth. It says here it's a minimum of 18 months. I would tell you that in my experience, it's at least 2 years usually. And that is really because we don't want people graduating before they're ready to graduate. And then usually after that, you're going to have about 3 to 6 months of the aftercare phase, and that's after graduation. We do have a great mentor program. We also have a great graduate program, so our alumni program, to continue to try to incorporate people, even if they're informal mentors, but to keep them connected and so forth. Next screen. I don't know if y'all have any questions about the Veterans Court program in Harris County. If you do, you can ask me now. If you think of one later, you can either give me a call or text me, which is probably the best way to get a hold of me, or emailing me any questions that you have. Because we've been doing this now for about 11 years, there are a lot more things for veterans that have just grown out of the interest and concern for the veterans, and because the VA has become much more involved and much more open to helping, trying to keep recidivism out and trying to keep veterans becoming criminal justice involved. So anyway, that's it. If you have any questions, let me know.
Thank you, Stacy. I believe we now have Tina Salisbury from Combined Arms, who would like to speak to y'all about her organization.
Oops, I was muted. Good afternoon, everyone. I'm Tina Salisbury. I'm the collaboration manager at Combined Arms. I know we have a few other organizations who are going to talk about what they do, but just to give a really quick overview of Combined Arms, if you're not familiar, we're a backbone collaborative veteran serving organization. We have over 77 member organizations under our collaborative, and those include other veteran service organizations, other nonprofits, government, education agencies, and we're based out of Houston. Our mission is to unite the community to accelerate the impact of veterans on Texas, and we're currently expanding into other areas throughout the state: Austin, Dallas, Fort Worth, El Paso, and we work with other collaborative partners around the nation. Out of all of those 77 member organizations, we have over 430 unique resources for veterans. So the way that the experience works for veterans or family members who come through our website, combinedarms.us, they would fill out a profile. They can take some assessments, and the way that they can get connected to our legal services, if they need legal assistance, they can take a legal assessment, fill out a few short questions, and then our platform is all Salesforce database platform, so it uses predictive analytics, and it's going to match organizations that that veteran or family member qualifies for based on the demographics that they put into their profile. So our legal services that we have 4 organizations, including Beacon Law and Lone Star Legal Aid, which you're going to hear from, Career and Recovery Resources, and Mental Health America. And there's about 14 legal resources in our system, and those include everything from clearing criminal history, consumer credit issues, disability law, employment law, family law, healthcare, housing, ID restoration, internal legal aid, so that's like the veteran court programs and veteran treatment courts, low-income taxpayer clinics, neighborhood problems, veteran benefit appeals, welfare and income assistance, and then wills and trusts. So if a veteran or a family member needs assistance with any of those, they would get connected to one of our organizations, and we would send a referral to that organization through our platform. We also have EchoLink, which many of our organizations have the ability to use EchoLink through their phone. It's an app on their phone. And we have what we call a no wrong door policy approach. So if a veteran is getting services at another organization and they might mention that they're having some legal difficulty or need some legal assistance, then that organization, even if they don't provide those services, they can quickly make an EchoLink referral to another organization, and that's how we're able to collaborate together. Trying to think if there's anything else. We've been around since about 2016. Our CEO, John Bursler, this was his thesis project for his master's in public administration. We do have a couple of board members on our board, Johnny Havens and Bill Pritchett, who are also attorneys in the area. And one of the other things that our organization does is we have community groups or affinity groups. And one of those affinity groups is the Combined Arms Veterans Attorneys Affinity Group. And the leader for that is Eric Almonte. So I can drop his contact information in the chat for everyone if you'd like to get in touch with him and see how you can get more involved with Combined Arms. He would be a great point of contact for you. But other than that, if your organizations or your offices have anything that you would like to collaborate with us on, or you'd like us to come out to any kind of like resource fair type events, or you have programs or resources that you offer veterans for free, just let us know and we'd be happy to help you advertise for those events or those programs. I think that's all I have. If there's any questions, let me know.
Thank you, Tina. I think now what we're going to do is have the other organizations who participated in today's CLE kind of go through and tell you a little bit about their services. And I believe, oh, Robert's already on it.
Hi, everyone. My name is Daytasia Bradford. I am the veteran liaison and paralegal here at Beacon Law. I just wanted to go over some of the assistance we help with. If you look at the PowerPoints, our bread and butter is ID restoration and sealing of criminal history, where we help with non-disclosures and expunctions. Both ID restoration and sealing of criminal history is like our bread and butter. That's what we're known for. We get a lot of referrals for those. We do help with Social Security disability. At this time, we're not helping with pro se divorce. That could change depending on the pandemic and our capability of being able to handle those cases. For landlord and tenant issues, we help with evictions, any type of breach of contract or an illegal lockout. For wills and estates, we are assisting with those. However, we are doing it very limited for safety regulations. So if you have anybody who may be interested in any of our services, you can put a referral in at the link below, which I did provide. We took off the password capability, so you can just go in to the website, put the client's name, address, telephone number, and we will reach out to them. Next slide. For this one, we have a Veterans Court program, which has been running for, I would say, since about October. It's fairly new. Unfortunately, we are paused at the moment due to the pandemic. The City of Houston Municipal Court is only accepting limited dockets. So I'm not sure when we will resume. It is tentative. However, if you do have a client you feel is could benefit from this, please put a referral in. So what Veterans Court is any veteran with any discharge who has any outstanding citations in the City of Houston Municipal Court database. We will partner with the City of Houston Municipal Court as well as Combined Arms so that the client can get their ticket dismissed. So what that looks like is the client is going to basically agree to engage with 3 different services within the Combined Arms system. Once they've engaged with those services, we'll get a report and turn it into the court. The court will then give us a document to give to the client to say that the charges were dismissed and all the fines were waived. So fairly easy, especially for those who are like disabled and aren't able to do a lot of community service. Any of the services provided in Combined Arms does suffice. So below I have where you can send me an email if you have any questions, or you can apply for your client or have your client apply at the website below. I know that was fairly quick, but that's just a brush over of what we do. Does anyone have any questions? No? Okay, well, that's pretty much it for us.
Hello, everybody. Again, Justin Thompson here with Lone Star Legal Aid with the Military and Veterans Unit. We serve Southeast Texas, so we serve Harris County all the way down to Matagorda, all the way back out to Beaumont, to Texarkana, Longview, Paris, down around to Belton. So we are the Legal Services Corporation funded 501c3, just like everybody else here. And we work with active duty veterans, dependents, and surviving spouses who are low income, typically under 300% of the poverty level. And our service area, like I said, 72 counties here in Southeast Texas, also offering civil legal aid, of course, veterans benefits, what we've been here talking about today, and then consumer bankruptcy, family, education issues if veterans are having issues with their children in school, employment, unemployment issues, discrimination, housing, eviction, foreclosures, of course, government benefits, Social Security, Medicare, Medicaid, and then we also have a group that's been working, doing disaster relief for a long time. Started with Harvey, probably was the big one, and then we've dealt with all the issues after that. We're happy to take referrals, not unlike everybody else here, and appreciate y'all being here with us today.
All right, hello everyone again. This is Diana Carlson. I work at the Veterans Law Clinic at South Texas College of Law. The Veterans Clinic is part of the Randall O. Sorrells Legal Clinics, and those house many different types of clinics. Robert, if you could go to the next slide for me. Thank you. Those house many different types of clinics. We have a tax clinic, an immigration clinic, a trademark clinic, and the Veterans Law Clinic falls into one of the biggest clinics, the civil practice clinics. So all of our legal clinics, we provide free legal services, much like Beacon Law, Lone Star Legal Aid, Houston Volunteer Lawyers. We service low income and disadvantaged families and individuals throughout the Houston metropolitan area. And our goal is to service these individuals while also providing an exceptional education to the law students who are enrolled in our clinics, to help them learn lawyering skills or to hone some skills as well. So the civil practice clinics, like I said, is one of our largest clinics, and under that umbrella are several other clinics. We have family law. We have a family law clinic, both basic services, meaning no property, no kids, and more complicated family law cases as well. We handle probate and estate planning, guardianship, landlord-tenant. We also do driver's license restoration and expunction and non-disclosures. And like I mentioned, the Veterans Clinic as well, who we focus on the appeals portion of the VA benefits, not necessarily helping veterans apply for benefits, as well as helping veterans get a discharge upgrade. Next slide, please, Robert. Thank you. So to qualify for our services, there are certain requirements. You have to be eligible. I should start by saying all of this is made possible, right, by our supporters, by our partners. We have certain grants here, the Rockwell Fund, Texas Access to Justice Foundation, and United Way. And each of these partners or supporters, they have different eligibility requirements, but on the right side of the screen, I have listed some of them for you. Income is a big one. It varies depending on the grant, but generally we would not accept a referral or a client who is more than 200% of the federal poverty level. There is some wiggle room there depending on the grant, but as a general rule, if it's more than that, we are unable to help them. We also focus on homeless and transient population, domestic violence victims. Immigration status can be an eligibility requirement, and as well as referrals from the community partner. If you're not sure if whoever you want to refer, or if you want to seek services, just call us. I have our number on the first slide, and like we've mentioned before, we'll be emailing these out. Just give us a call, and we'll go through the intake process and get that all figured out. I saw a comment here that they're only seeing Lone Star Legal Aid's last slide. I'm not sure. Is anyone else having that problem? Okay. Well, I'll make sure that we include the slides when we email everyone. That way you can look over this information and have our contact information as well.
All right, I guess I'm next. I'm Robert Morales. I'm with Houston Volunteer Lawyers. I'm supervising attorney for our veterans program. Our website is listed there, makejusticehappen.org. You can email us. So with COVID and everything, and like everyone else, we went remote. So we have our virtual legal clinics now, Fridays from 2 to 5, and once a month we're doing Saturday clinic as well, which we used to do Saturday clinics going to kind of the outlying areas, but for now, and in the foreseeable future, we'll be doing virtual clinics. Now, the way we're doing it, instead of doing walk-ins, because obviously it's virtual now, we essentially schedule an applicant 1 per hour per attorney. So it really depends on the amount of volunteer attorneys that we get. So if you would like to volunteer for one of our clinics, let us know, and we can set you up for 1 every hour or however many hours you have. The way we are right now, essentially, it's pretty much as many volunteer attorneys we can accommodate, and that's pretty much every Friday. Also, we have pro bono cases that are available for legal representation. For the most part, our model is to have volunteer attorneys pick up the cases pro bono. And those cases are going to be veterans or surviving spouses of veterans that are making up to 300% of the federal poverty guidelines. And we'll take cases available in Harris County, Fort Bend, Montgomery, Brazoria, Galveston, and 12 other surrounding counties. Let's see what else. So we pretty much take every kind of case except criminal, traffic, immigration, and fee generating cases. So if it's one of those PI cases that's gonna make you some money, we'll leave that for the private attorneys to take. We won't take those. So that means we take VA benefits, all kinds, military service discharge upgrades, family, probate, simple estate planning, bankruptcy, guardianship, tax, real property, landlord, tenant, you name it, we'll pretty much take it. And that's all I got. And now for the slide everybody's been waiting for. If I can get to it. So this is the CLE information. It's also going to be emailed out, but I was asked what's the difference between the live webinar and recorded webinar. The live webinar is probably the one that you should use, but if you use the recorded one, that's fine. If you're watching this later on video that's recorded, feel free to use a recorded webinar. That one doesn't expire until 2021 at some point, but you can use either one and you'll be fine. And it's 4 hours, and the sponsor is Houston Bar Association if you're looking it up, but just feel free. And if there's any questions, I will have to stop sharing my screen so I can look at them. Okay. So let me post it in the chat actually. Okay, so I posted the CLE credit numbers in the chat. If there's any other questions, feel free to ask them. Okay, questions. Okay, did that. Okay, so it seems like there was a problem with the slides at one point, but we'll email those out to everyone. Okay. If there's no other questions, that's it.
I think, yeah, Alex Wathan had a question for Lone Star about non-resident veterans. And I believe Lone Star answered.
Alex, this is Justin. Yeah, we do take non-citizens. We do have to have some proof that they're legal residents, like typically, you know, their A number with a copy of their green card or their permanent residency certificate, but we can help them out.
Okay, well, that's it for today. Thank y'all so much for joining us. We hope it was helpful. We'll be sending that email to y'all within the next couple of days, so be on the lookout for that. If by next week you have not received it, please email me. I'll put my email in the chat just to make sure everyone gets it. If you haven't received it by next week, like I said, just shoot me an email. I can send it to you personally. If that is all from my end, if none of our other panelists have anything to add.
Thank you all for attending.